Good morning, ladies and gentlemen.
Good
Morning,
morning,
Judge.
Judge.
Morning, Judge.
Good morning, Mr. King.
Morning.
Good morning.
May I enter a breakout, attorney, please?
I'm sorry, what you say, sir?
I said, may I enter the breakout room for 2 seconds with my attorney, please, to get her number, because I haven't met her yet.
Who is your attorney?
I have no clue, sir. This is just my
What's your
second.
name? What's your name?
I said, I have no clue, sir.
I asked, what's your name?
Oh, my name is Joshua Williams.
That would be me, Judge.
Okay. You want a breakout room?
Yes, please.
Thank you.
Go ahead, John. Mr. Cooper, good morning.
Good morning, Judge. How are you?
Good, sir. How are you?
I'm all right. Yes.
You sound sad. What do you have this morning?
Oh, I got an email yesterday indicating to come in on Joshua Johnson. Dominic DeGrazia is the prosecutor. He's here on that.
Okay. Yes.
Case number 2305-513001. People of the state of Michigan versus Joshua Johnson. Defendant is charged in count 1, homicide, murder, second degree, count 2, weapons felony firearm.
Appearances for the record, please.
Dominic DeGrazia, P69815 on behalf of the people.
And Renee Cooper for Mr. Johnson.
All right. So I believe this matter was actually scheduled for yesterday. I put it over to today. Okay. Didn't meet either one of you guys here.
Judge, it was actually set for the 25th for an exam. I think the issue we have is writting the defendant out. He's currently in federal custody at the Saginaw County Jail. I emailed your clerk last week to get a writ signed. And I wasn't in the office yesterday, but I don't know if she got the writ, but I can email it back. But I guess the issue we have now is that to get him here next week, the county says that they need 2 weeks and 2 days to writ somebody out. If you can sign the writ and email it back to me today, I can get it to him and hope that we can get him here for next week. But I don't know if we're going to be able to.
Why don't we shoot for May 2nd then?
Well, I have a trial. I don't believe it should go, but it is set before Judge Cusick to start on May 2nd.
So you say you think it may not go. How about May 2nd at 1:30?
Oh, well, what if it does go, Judge?
How are you?
I mean, I know the facts are such that it should not go, but the correct offer is being worked on still by the prosecution, and if it doesn't come, it will go. I don't think it's that flexible. I just don't want. Let me say that right now, I have a trial scheduled that morning.
And I'm not sure how Judge Cusick operates. Does he pick the jury one day and start with opening statements the next?
Oh, no, he would pick the jury, and then we'd go into instructions, we'd go into opening statements, we'd move right along.
Okay. Everyone has their own style.
True.
How long do you anticipate the trial will last?
2 days, Judge.
How about May 9th?
Okay, that's a problem too, Judge. I can explain the problem if you wish to hear it. I'm supposed to start a homicide tomorrow before Judge Bridget Hathaway. She's not going to be able to start it. We sat in chambers yesterday coming up with dates, and she wants to set the homicide trial for a man who's been in jail for more than 2 years on May 8th. It isn't set right now. We have to get the trial that I have set for May 8th moved because it's just a 4-year felony. So we were going to work on, I think Judge Hathaway was going to work on trying to get rid of my problem on May 8th, which is Chancellor Searcy is the defendant's name. The trial is supposed to start May 8th, but it's a common law crimes case. It was a hung jury the first time.
You have a trial starting on May 2nd. How about May 1st? Although that's my non-homicide day, I'll do it.
Oh, that would be really appreciated, Judge.
May 1st at 1:30?
Sure, thank you.
Judge, is Miss Reynolds there today so that I can send her a writ right after we're
Yes,
done?
she is.
Okay.
She says she has it.
I'm gonna have to send a new one since the date changed, but I'll send it over right now.
There's not a date on it, she says.
Oh, well. I'll send one anyway then, I guess, maybe if I didn't send it out right.
Okay, you just want us to have this written. Go ahead and send it.
Thank you.
Thank you much, Judge.
All right, no problem. May
I
1st,
hope you
1:30.
okay.
Bond continue. Ms. LaShawn, good morning.
Good morning, Your Honor. I have Mr. Hargrove, PCC.
Okay.
He's in the Wayne jail, Judge.
And good morning, Judge. That's my case. There is a co-defendant on that matter. David Cripps is representing the co-defendant.
Yeah, I haven't seen Mr. Cripps yet.
And I would ask that we schedule both these for a simultaneous exam since they're going to require the same evidence to be presented in court.
Will you reach out to Mr. Cripps?
Thank you, Judge.
All right, we'll come back to you, Ms. LaShawn. Ms. Bates. Bates, are you still here?
Prosecutor for this
Farage. Sehar Faraj.
Good morning, Your Honor.
Good morning. Counsel Miller.
I am one of the defense co-counsels for Kenneth Davis, checking in for the PCC. I'm sorry, I'm just making my way to 36th District Court right now.
Who is the other?
Lauren Anderson.
Where's Miss Anderson?
She is logging on right now.
And good morning, Judge. I'm covering that for Elizabeth Moore.
Okay. I forgot I put Miss Bates in the waiting. Breakout. Okay, Ms. Bates,
Good morning, Judge.
are you ready on Williams?
Yes, we are ready.
Calling case number 2305-630-201. People of the state of Michigan versus Joshua Williams. Defendant is charged in count 1, criminal sexual conduct, 4th degree. Count 2, criminal sexual conduct, 4th degree. Count 3, criminal sexual conduct, 4th degree. Defendant has a habitual offender, 30 notice.
Appearances for the record, please.
Thank you, Your Honor. Erica Moses on behalf of the people, P78491.
And good morning. Good morning, Your Honor. Melanie Bates, P76080, appearing on behalf of Joshua Williams, who is present via Zoom through the Wayne County Jail.
Mr. Williams, tell us your name.
My name is Joshua Martez Williams, Judge. Good morning, everybody.
Good morning. What's your pleasure, Ms. Bates?
Your Honor, we'd like to schedule the preliminary exam.
How is April 24th at 12 o'clock?
Judge, I start a jury trial on the 24th and 3rd Circuit. Would it be possible to do the 27th or 28th?
27th is my homicide day.
Okay, I'm sorry, Judge.
How's the 28th at 10:30?
That works for the people.
Your Honor, can we do 11? Would 11 work?
We can do 11.
Okay.
April 28th at 11 o'clock, bond will be continued.
Your Honor, Mr. Williams, when we went to the breakout room, he wants me to address his bond. I understand he had a bond redetermination hearing that reduced his $25,000 cash bond to a $25,000 cash 10%. And Your Honor, he is trying to come up with the money. He does have 3 children, has his living partner at home who is trying to come up with that money. But she is not able to have anybody sign for the bond. The bond person wants some type of signature, but because she's not working, that's unable to occur. And she's unable to come up with basically the $2,000 for the 10%. Your Honor, so I'm asking if you would consider another reduction where at least she has $700 she can put towards his bond. And one of the main things I wanted to point out to the court is that Mr. Williams is working at All Weather, and his significant other, his live-in partner, has been in constant communication with his manager, and his manager is going to hold that position just until Thursday. And if he loses that, then he won't be able to support their children. She's not working right now because she's taking care of the children. And I think that's the main thing here is that if he can get released before Thursday, he'll be able to go back to work. And we're not asking for something that's unreasonable, that they do have the $700.
Judge, I think given the nature of the charges, I think what bond was ultimately reduced to is more than reasonable. We're dealing with CSE fourth degree. We're going to have the exam next week. I'm not sure what that bond redetermination hearing if a DSU report was ordered, but I'd ask that that be done first before Your Honor, and possibly Your Honor hear the testimony at exam before Your Honor reduces bond further.
Well, the situation is this, Ms. Moses, is that if the defendant had adequate means, he wouldn't be sitting in jail right now. But because he does not have money, we want to fill our jails up, people who can't afford to post a bond. I think not. So I will reduce the bond to 7,000, 10%. No contact with any children under the age of 16.
Thank you very much, Your Honor. We appreciate that.
Thank you, Judge.
And Mr. Williams, you did hear your court date, correct?
Would that be the 28th at 10:30?
April 28th at 11 o'clock.
Okay, April 28th at 11 o'clock, 4/28, 11 p.m., 11 a.m.
But I like your thinking. Come at 10:30, like you said.
Yes, sir. I'm trying to do best for my family. We're gonna get through this.
Thank you, Your Honor. Everyone have a great day.
Ms. Michon, Mr. Cripps is here.
Good morning. See you later.
Yes.
Calling case number 23056-117, people of the state of Michigan versus defendant number 1, Demarion Hargrove, and defendant number 2, Charlie Martin. Both defendants are charged in count 1, homicide, murder, 2nd degree. Both defendants are charged in count 2, weapons, felony, firearm. Both defendants are charged in count 3, assault with a dangerous weapon. Both defendants are charged in count 4, weapons, felony, firearm.
Appearances for the record, please.
Good morning, and may it please us. Excuse me. Good morning, and may it please this honorable court. APA Jonathan Hitz appearing on behalf of the people. P85288.
And good morning, Your Honor. May it please the court. Kim Michon, Neighborhood Defender Services, P59167. It's my privilege to represent Mr. Hargrove, who is in the Wayne County Jail. We would waive his appearance for these purposes.
And good morning, Your Honor. David Cripps, P34972, appearing on behalf of Mr. Charlie Martin. We have no objection to Zoom either.
All right. Are you waiving your client's appearance, Mr. Cripps?
Yes, I am, Your Honor.
Okay, what's your question, counsel?
Your Honor, on behalf of Mr. Hargrove, we do not have discovery as of yet. All I have are 2 body camera footages. Quite frankly, MIDC requires me to see my client within 72 hours. I don't have even a copy of the information. I don't know when this happened, where this happened, or who got dead. I've had an investigator with me. I've had this case 11 days, and I still don't know what happened. I'm asking for a brief adjournment and for prosecution to turn over the discovery.
On behalf of Mr. Martin, I join in that request.
And Judge King, I'd be happy to turn over all discovery to both Ms. Michon and Mr. Cripps, and I apologize for my voice failing me a bit here today. I submitted a proposed protective order to the court in the matter of Mr. Hargrave that Ms. Michon, I understand, does not have an objection to. I sent an identical order to Mr. Cripps. I haven't heard back from him yet on that order. As soon as I have a protective order entered in both matter, I will turn over all discovery.
Okay, Mr. Cripps, you have any issue with the order, proposed order?
No, I don't, Your Honor.
Likewise, Judge.
All right, so start getting that ready, Mr. Hitz. Get it over to them as soon as possible. I will adjourn this probable cause conference to I'll adjourn it to April 27th at 8:30.
That works for Mr. Martin.
That works for Mr. Hargrove, Judge.
And that works for me as well. Thank you, Your Honor.
Thank you.
Have a good day, everybody.
You too.
You too.
Okay, so we have Ms. Anderson here.
Good morning, Your Honor.
Morning, Ms. Anderson.
How are you today?
Counsel was here looking for the jail though.
Judge, I'm happy to waive his appearance. I've been in regular contact with him.
You're on both of his cases, Ms. Anderson?
Yes, Your Honor.
She has an 8 weeks.
Calling case number 2305-630301, people of the state of Michigan versus Kenneth Davis Jr. Defendant is charged in count 1 and 2, criminal sexual conduct, first degree. Count 3, home invasion, first degree. Count 4, criminal sexual conduct, fourth degree. Defendant also has case number 2305-630401. Defendant is charged in counts 1, 2, and 3, criminal sexual conduct, third degree. Count 4, criminal sexual conduct, fourth degree.
Appearances for the record, please.
Good morning, Your Honor. Carly Cox on behalf of the people, standing in for APA Elizabeth Moore on both matters. My P number is 81911.
And good morning, Your Honor. Neighborhood Defender Service by Lauren Anderson, P85191, along with co-counsel Sahar Faraj on behalf of Kenneth Davis. He is incarcerated in the Wayne County Jail, and I would ask to waive his appearance.
Ms. Farage?
Good morning, Your Honor. Attorney Sahar Faraj appearing on behalf of Mr. Davis.
Your P number?
85175.
For the waive the defendant's presence, what's your pleasure?
Your Honor, I have received discovery from the Assistant Prosecuting Attorney. We are thankful for that. I would like to refer Mr. Davis for competency referral at this time.
I take it there's some issue with or question as to his ability to adequately assist in his defense.
Yes, Judge, for all of the prongs of competency, we have gotten to know Mr. Davis relatively well since his incarceration. He's suffering from severe mental illness, and I don't think he can assist in his defense right now.
All right. Court will continue the plea of not guilty. I'll refer it for competency evaluation. Set a review date for July 18th, 2023 at 8:30.
Thank you, Judge.
Thank you, Your Honor.
Final be continued.
Thank you. Have a good day, everyone.
You too. Colassa.
Good morning, Your Honor.
Good morning, sir. What can I do for you?
Your Honor, I'm here for Michael Flood. I'm standing in for Attorney Jaffe again.
Okay.
Calling case number 2305-618-401. People of the state of Michigan versus Michael Flood. Defendant is charged in count 1, larceny from the person. Count 2, assault with a dangerous weapon. Count 3, weapons, felony, firearm.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Your Honor. Attorney Scott Colasso, standing in for Attorney of Record Brent Jaffe on behalf of Michael Flood, P84583. Mr. Flood is present via Zoom. Michael, can you please identify yourself for the record?
Michael Flood.
What's your pleasure, counsel?
Yes, Your Honor. Today is the adjourned PCC date from last week. I do appreciate giving me the brief adjournment. I was able to discuss this with Mr. Jaffe. He would like me to set this for an in-person exam. We have not received discovery, however, so I would be asking for an exam sometime in May.
No.
I do have Mr. Jaffe's schedule, and I can try and set a date based on what he has available.
How is April 24th at 12 o'clock?
He has an in-person pretrial in, I think that's Southfield at that time.
April 26th, morning or afternoon?
He's booked on the 26th. The 28th, he's completely clear.
So my clerk tells me that we got a call from Mr. Jaffe's office saying that they don't have this case.
It was that was my understanding yesterday, but Mr. Flood was able to meet with Mr. Jaffe and work out an agreement. Mr. Jaffe is on this case. I personally am not retained. I'm standing in. There's an issue with the Register of Actions reflecting that I was the retained counsel, but Mr. Jaffe is retained counsel in this case.
What about April 28th at 11:30?
That's clear for Mr. Jaffe, Your Honor.
April 28th at 11:30, Ronald, we continue.
Mr. Jaffe, please send our office discovery.
Yes, did you not receive the paper discovery?
I don't think we've received any discovery at this point.
Okay, I'll send it again. I'll do it. Thanks.
Thank you, Your Honor.
Thank you. We still have Park Road. Oh, no, we did Park Road. We're down to 10 o'clock.
So, Mr. Keaton,
How you doing, Your Honor?
Good, how about yourself?
All right.
that's the order that they wanted to adjourn Hudson. The 11:30. I tried to get confirmation and make sure. So I didn't take.
Days and time.
If you want to pick, should be on their phone. Video or something. And what's his name? Okay, the one that fell 600 before Judge Jefferson. Get some possession tax. So, you know, I'm looking at some possession. Oh.
Ms. Mayor,
Yep, good morning.
good morning, can I help you?
Yep, I'm here waiting for Miss Ripley. I think she was logged in earlier. She needs a new time for an exam of ours tomorrow.
What's the defendant's name?
Reginald Whitlow.
What time was it scheduled for?
It is scheduled for 9:15. Yep, 9:15 tomorrow.
Did she tell you what the problem is?
Yeah, her witnesses aren't available.
Comes from Strickland now. Ms. Ripley,
Good morning, Judge.
good morning. I understand that you have an issue with Reginald Whitlow tomorrow.
Yes, Judge. My complainant and his mother they have a Zoom for a juvenile case on which he's the victim, also at 9 a.m. tomorrow. It's supposed to start at 9 a.m. So they would be unable to, I guess, Zoom into that court hearing and then also be at ours.
What kind of hearing is that?
So he was the victim of, I think, a sexual assault by a juvenile.
Ours is scheduled for 9:15.
Yes.
They can Zoom in from here.
I just don't know how long that their Zoom is going to take, Judge. That's all, or what part. I'm not sure like the full capacity of the hearing. So I wasn't sure if it started at 9 or, if it was like kind of like our cases here where everybody starts at 9, you don't know when you're going to be called. So I just wouldn't know when they would be done is the real thing. So I don't know if they would be done by 9:15.
Which matter was set first, do you know?
I believe theirs, because when I sent the subpoenas to my officer in charge right after our hearing, and he contacted the family right then, and they said that they had this hearing already.
Give me tomorrow's. Give me 1 second.
I'm sorry, Judge.
I said, give me a few minutes.
Okay.
I'm gonna do 11:45.
That would be fine for me.
11:45. Sorry, that should work, Judge.
Okay, 11:45.
Okay. Thank you so much, Judge. Thank you, Ms. Barron.
Thank you.
Thank you. Bye.
I'm gonna put that on the record. This is case 23056252001 versus Reginald Whitlow. Defendant is charged in count 1, child abuse, 3rd degree. Matter is scheduled for preliminary examination on April 19th at 9:15. The court just met with the parties and they stipulate to adjourning it from 9:15 to 11:45 due to the complainant being unavailable at that time. I'll be continued. So we'll get out of here early tomorrow. Time today.
They was just telling me not to say it.
Oh my God. Don't judge me. So, doing that. Watch me.
All right, I'll let Marcus. Right back. That's Pete. So I'm going to do 2, 3, 0, 5, 5, 5, 8, 0, 1. Yeah, I have to do the next 4 days. And then when I hit enter, the date didn't pop up. Because I didn't do the math, and it was no date there. I had to go back in. It didn't say, just when I knew it was what to do. The date you put. All the math. It didn't pop up. So, and then it did. Oh, when you try to do it, it was like, it took 2 months. So like, you go to the calendar. Yeah. They did, yeah, they used to do that. 5, 4. Not like that. Actually. When you hit F9, then it says, yeah, that's the change. Right, yeah, so that's a change. So the first one, Y or N. And then the next one would be the refrain or put one of those options in. Okay, I got you. They could put some hands. Oh. You know, I was off last week, so I come back and I'm looking at all these changes. Yeah, people call me, what's wrong with your system? I'm like, I don't know. Oh, yeah, I saw the write-up yesterday. Yeah, I'm
Your Honor, I sent my 404 meeting notice. Did you want a paper copy as well?
Yes.
Your Honor, is it okay if I just, when I do my minutes, just come bring them right to you? I observed other issues. Oh.
Good morning. How you doing? Good. All right. Miss Kitty? Yeah, that's what I was gonna ask. That's what I came over for.
Oh, for you to do a dismissal?
Yeah.
All right.
I'll get Mr. Hawkins for.
Yes.
Okay. Okay. Yeah. Takes me all the way down to the next.
Madam Clerk. Madam Clerk,
Mhm.
what's going on with Hudson?
I got a darn,
Oh, God, John, okay.
and Lieutenant Dabney,
They sent it back.
right,
Okay, I got that. But, okay, but it's gonna bring over here. Yeah. For that journey. Okay. Hicks, they didn't bring over, they supposed to bring them over.
What's that mean?
It's gonna be probably a little late. They gonna start on time. I don't know why they didn't bring them over.
and they called and said they got weathers down.
Yeah, I got that. Charlie's gonna be on time anyway.
Honestly, you never know.
Man.
I have it's a hell. So it's just, it's two, but when I close in, I'm gonna say. Do you never anything? I will take it right. Okay. Sarah, SARA. But no, E and boy, ONOMO. It's P84189. So, thank you.
No, they didn't bring over, he didn't. Huh? Who's this attorney? The Tubbs? Hey. No, just this.
Okay, I appreciate it, thank you. No problem. Yeah. Like my parents and grandparents used to always tell me my head wasn't attached to my body. I lose that too. There you go.
Yeah, I've heard that since.
It's gonna be a minute on Hicks because they didn't bring him over.
Okay.
Uh-huh. Yeah. Okay. All right. All right. Got it, John. Right. Oh.
That was downstairs.
Yes.
Anyone see Mr. Tubbs?
Pardon me, Your Honor.
Mr. Tubbs not here?
No.
This office called first, they asked about a different campus. I don't know.
Thank you. to give us an ETA on this? Oh. Mr. Taylor, right? He's in federal court, Mr. Tubbs.
Yeah, the ETA.
Are we adjourning? Are we meeting?
Waiting to hear from Mr. Toad. So I'm supposed to be contacting Mr. Toad to call us. It's like it's going to be adjourned.
Karen, will we set the date today or will we wait for Mr. Tuttle's?
We need to set it today, I understand, you have witnesses that
Yes,
aren't local, so to speak. So
can I grab them real quick to see if the date works for them and if the date?
I don't have a date yet.
Oh.
This guy. They have
Yeah, what?
get some feedback from him.
Kevin Tuttle's?
I'm sorry.
You're talking about Tuttle's?
Yes.
Okay, so would we set the date today or why
I
didn't
would
we
like
email?
to. I would like to set it today, but I can't just pick a date for him because he may not be available again.
Okay.
We're still trying to reach him. Sounds like he's in trial.
Should I just hang out a little bit?
Yes,
Okay. I can let the officers know they're good to go.
yes.
Thank you.
Can you call Judge Johnson? See if they have anything on?
Yes, Judge.
Yeah. You know, I'm gonna take it back.
Okay. Okay. Mr. Thomas is on his way now.
Are we holding it then?
Yes.
No, but I'm gonna call my OIC and see if she's walking out.
Can we stop them at the front door? Go next door.
Yeah. Yeah, I'm gonna come back. Okay, thanks. Yeah. They're calling, yeah. Judge can't come on the street. Shout out for us.
Yeah, yeah.
Yeah, Judge Kenneth, job.
Yes. He is, because they said when I first got there, he didn't bring one yet. He should.
I changed it.
You're supposed to take a plea.
Yeah, I don't understand it. You know, yeah, I'm moving, you know, speech, like, give us two, just talk.
Yeah. Before you get a trial.
You know, we have a child. It's really big.
Oh. Not much.
Bad, so it's bad.
Right? Yeah. I'm not, yeah. It's not just. I just wanted to. What do you do now? I've got officers here for doing it.
Just that, Mason, the city. So much more right.
Okay.
Yeah. You say it's in corporate way. You in person? Okay, I'll have our officers go to you. They say Tubbs is at the door waiting.
Tubbs right there.
Oh. I see you come in.
He's been there for about 5 to 10 minutes. Walk right past Tubbs.
I'm saying, he was sitting there when I work.
Yeah.
If you do a plea, and my client changed his mind, so that delayed the process. We had to raise speed, trial rights, and so on and so forth.
Around second.
Sorry for the delay.
Both matters are up?
No. This is just the second degree. And we'll be here to discuss a 4-4B motion.
Right.
All right.
What happened on the other things? What happened on the first
It was
degree?
bound over. The homicide premeditated was bound over.
That's what I thought.
Yes. So we're only here to on the 4-4B, but she has 2 witnesses. To put out the position on the record.
Some reason I got those files. Calling case 2355696, people of the state of Michigan versus Cortez Keanu Hicks. Defendant is charged with count 1 homicide, murder, second degree. Count 2 operating while intoxicated, causing death. Count 3 reckless driving, causing death. Count 4 operating while intoxicated, causing serious injury. Count 5 operating while intoxicated, causing serious injury. Count 6 operating while intoxicated, causing serious injury. Count 7 reckless driving, causing serious impairment of the body function. Count 8 reckless driving, causing serious impairment of the body function. Count 9 reckless driving, causing serious impairment of the body function. Appearances for the record.
Good morning, Your Honor. Sarah Bell on behalf of the people, PH 40189.
Good morning, Your Honor. May it please this honorable court, Antonio details on behalf of my client, that's Mr. Cortez Hicks, who stand to my near left.
Tell me your name for the record, sir. All right, so this matter was held in part on April 4th, continued to today's date. There was an issue as to the 404B evidence people were seeking to admit. I do have notice of intent to introduce evidence of defendants of the acts or wrongs pursuant to Michigan Rules of Evidence 404B submitted by the prosecution. Did I receive some from you, Mr. Tubbs?
I have my heart.
Okay. All right. So did you have an opportunity to read this?
Yes.
Motion? Okay. You want to respond? Yes. Go ahead.
My position is this, Your Honor. As much as the people want to say that it's not offered to or to show the propensity that do this. My position is under 403 relevant or obviously evidence that's otherwise relevant can be not admitted if it has if it's probative value, it's substantially outweighed by dangers of prejudice, so on and so forth. And I think this would be extremely prejudicial to my client to bring this information. I don't think it's even necessary at this particular time, given the information that's already been, brought before this court. I think that it is at this time a question of fact, and that is more than enough. But I believe this court to hear the information that the prosecutor is offering is not going to do anything but make this judge think that he was acting in conformity, with prior acts, and that's substantially prejudicial to my client. For this court to think that he's acting in conformity to something he usually does, but it's just his way of conducting himself. Again, I think it's unnecessary, but I believe it's substantially it's dangers of prejudice. It's substantially or the prejudicial value is substantially outweighed by dangers of prejudice.
Ms. Bonilla?
Your Honor, it's the people's position that we're introducing this prior bad act just for intent, which is a proper purpose under 404. If this was a jury trial, we would give a limiting instruction, but I believe the court can make that determination that this is being used solely just to show intent, is to show his willful and wanton actions beforehand. So people are respectfully requesting that the court allow this.
That's my reading of the people's motion, Mr. Tubbs, is that the sole purpose of this evidence being introduced is not to prejudice the court, but to show the defendant's actions were willful and wanton. So my understanding is that prior to the incident that we're here on, the defendant was drunk driving and driving recklessly throughout the streets, running red lights and the like. And then we have this incident, the same kind of conduct. So if he was arrested for that kind of reckless behavior, at that point in time, it's the people's intention to show that his actions were willful and wanton, that he had a high disregard for the safety of other folks out there on the roadway. And that's only relevant because of what the defendant is charged with here, which is second-degree murder. That there was a wanton and willful disregard of the likelihood that the natural tendency of his actions would cause death or great bodily harm, kill the complainant here. Her name is Turgeon Dana. So the court is going to allow the 404B evidence for exam purposes.
I have a question.
Yes, sir.
If there's the people's position that this was an intentional act, I understand that.
When we say intent, we're talking about that third prong of second degree. Not be intent in the normal sense of the word, but the actions being willful, wanton disregard for the natural tendencies of his actions.
I was still believe that this is, this probative value. We have enough, in my opinion, to say that this is a question of fact and this one can be bound over. I just don't think that.
Well, I don't know that yet. I don't know the facts of this case. What I'm hearing from the prosecution is they're charging that third prong of intent in the second degree murder. So they have to show something, especially in a vehicular accident. They have to show something more than just speeding. So they're showing that not only was he speeding, his driving was reckless, but that he's done this on the prior occasion, which makes it even more wanton and willful.
With my understanding of the facts in the first case is that he was asleep at the wheel. It was no.
I haven't heard any evidence as of yet.
So there's no evidence. None of these officers are going to be able to come and say, well, he was driving recklessly. You know, they pulled up on him.
I thought that's exactly what she was trying to.
Your Honor, I would disagree. That's what they're going to testify to. His driving prior to being pulled over during a traffic stop.
Okay.
All right, that being said, do you have any other preliminary matters?
Not for the future.
I'll touch.
Here.
Did you get the identity too?
Yes.
Ready to call your first witness?
Yes, Your Honor. At this time, people call Officer Abraham Uza.
Mr. Drain is here. Good morning, sir. Please step forward, give your name and spelling to the young lady to your right. Please raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you, sir. Please have a seat. The witness box right next to me. Voice up nice and loud and speak to the microphone that's to your left. You may begin when you're ready.
Thank you. Can you please restate your name again for the record?
Officer Uza.
And where are you currently employed at?
You're running police department.
And in what capacity? An officer?
I am police officer.
For how long?
Approximately 2 years.
Were you employed in this capacity on February 12th of 2023?
Yes.
Did you in fact work on that date?
Yes.
Were you by yourself or with a partner?
I was by myself.
And did your duties take you at or near eastbound on Ford Road?
Yes.
And were you on foot or were you in scout?
I was in holding mark patrol.
Okay. And when you're at that location, what if any observations do you make?
I observed the defendant's vehicle traveling eastbound Ford Road.
And what kind of vehicle was it?
The Chevy Malibu.
And what other observations, if any, do you make?
I observed the vehicle swerve multiple times in the center. We were driving in the number 3 lane, so closest to the center turn lane. I observed the vehicle swerve into the center turn lane multiple times, continuing eastbound.
That drew your attention?
Yes.
And what if anything happens after that?
The vehicle also ran 2 solid red lights. After the first one, I attempted to make a traffic stop.
When you say you attempted to make a traffic stop, what did you do then? Did you turn your lights on?
So yes, I activated my emergency lights and sirens. The vehicle failed to stop. Then continued after the second solid red light, traveled northbound, Telegraph, and the southbound traffic lanes.
Okay, so he's going the wrong way.
Correct.
This individual. Does this individual crash into anything or?
Before running the first red light on Ford Road approaching Telegraph, the vehicle almost struck a traffic sign that was divided eastbound and westbound traffic on Ford Road. And then it swerved out of the way to correct its tag, that way it didn't strike the traffic sign.
Okay. Now, eventually, does this vehicle come to a stop?
Yes,
And you observe individuals in this vehicle?
yes, there were two individuals.
Okay. Do you see an individual, did you see let me rephrase, the driver of the vehicle? Did you speak to that individual?
Yes,
At that time, did they have a mask on?
they did not.
Objection, I would.
Your Honor, at this time, can people pull their, never mind. Can you look around the courtroom and see if you observe that individual? Can you please point to that individual and state something that they are wearing?
Green shirt.
Your Honor, may the record reflect the identification of the defendant?
So no,
And did you perform field sobriety tests on the defendant?
Yes,
How many?
3.
And what were they? The 3 of them? Just the
First,
time.
the first one was. The first one was, guy reflect on my own school.
Would that refresh your recollection?
Yes.
Your Honor, may the witness review his report? Go
yes,
ahead.
Okay.
Did that refresh your memory?
Yes.
Okay. What were the 3 tests that you conducted?
The horizontal gaze and stagnance. I did the one leg stand and the walk turn.
Okay. And how did the defendant perform during these tests?
In the horizontal gaze and stagnance, the defendant had no resting eye stagnance. He had lack of smooth pursuit in both eyes. He had distinct and sustained nystagmus and maximum deviation. On the walk and turn, the defendant failed to walk the correct number of steps, forming 10 steps forward. Did an improper turn by taking one big step to turn around. Walk 10 steps backwards, each step on both forward and backwards to the starting position, where none were hip to toe. All of them were off the center line. In the one leg stand, the defendant attempted to complete the task, counting to 2, fell off balance by hopping and using his arms to keep his balance. And at that time, the defendant couldn't keep his balance when I terminated that exercise for safety.
Did you eventually place this individual under arrest?
Yes.
No further questions, Your Honor.
cross-examine.
Good morning. Okay. When you spoke to the client, did you ask him whether or not he was under the influence of any medications?
I don't recall asking.
If you did ask him that, would that be reflected in your report?
It should, but it's not in the report, so I probably didn't ask him.
You didn't ask that question. So you don't know whether or not he was under the influence of any type of medication? You don't know.
That's correct.
No further questions.
Can you redirect?
No, Your Honor.
Thank you, sir. You may step down.
May I comment?
Yes, please.
Your Honor, at this time, people call Sergeant Joseph Stevens.
If you give your name and spell it to the court. Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. So please have a seat. The witness box right up here next to me. Thank you. Ready.
Thank you, Your Honor. Can you please restate your name again for the record?
Sergeant Joseph Stevens,
And where are you currently employed at?
Dearborn Police Department,
For how long?
9.5 years.
Were you employed in this capacity on February 12th of 2023?
Yes, I was.
Did you in fact work on that date?
Yes, I did.
And did you become involved in an investigation of an individual?
Yes, I was.
What was your role in that investigation?
I operated the Dive Master during the lines.
Do you see that individual in court today?
Yes, sitting, sure.
Your Honor, may the record reflect identification of the defendant?
So noted.
And on the same question, were you certified to operate a breath test instrument?
Yes, ma'am.
And is there a period that you must observe the individual before administering that test?
Yes, ma'am. After giving consent to do the Data Master testers of the 2-minute observation period, which I did.
Okay. And during that time, is there anything that the defendant should not be doing?
Basically, no, I'm not putting anything in their mouth, touching their face or anything, and to avoid that, I generally leave the subject of the test that we did, inadvertently put their things into their face.
And what if any other procedures are done before administering this test?
First, you just read the count test rights on it's on the backside of the DI 177 form, which is a standard form that we use. Count the test rights at that time. Sent it to the breath test. Waited the 15-minute observation period. And administered the breath test.
Did you receive results for this test?
Yes, sir.
Your Honor, may I approach? I'm handing you people's proposed exhibit 8. Does this document look familiar?
Yes, ma'am. This is a ODA form which prints the test results from our data master machine.
Is there a subject name on this document?
Yes.
Whose name is on that?
Cortez K. Hicks.
Does this document fairly and accurately depict the document that you received for the results for the data master?
Yes, it does.
Your Honor, at this time, people move to omit people's exhibit 8.
Any objection?
Your Honor.
Admit it.
And can you please describe the results of the blood alcohol content from this test?
Yes, ma'am. There was 2 subject samples that were taken, meaning that the subject gave 2 valid breaths. The first sample was a 0.18 BAC at 2:38 a.m. And then the second sample was also 0.18 BAC at 2:41.
Thank you. No further questions.
Cross-examined.
How long have you been trained to operate the Data Master?
I've been a police officer with Dearborn Heights for 9.5 years now. I've been certified the entire time in the office. No, I'm sorry. It's probably been about 8.5 years. I'd say that the first year when I started here.
And the machine that you used when the question of February 12th, had it been, when was the last time it had been calibrated?
That I do not know, sir. Our traffic bureau, they do the calibration of our data master on a regular basis. But I'm not sure when the last time was prior to that test.
So you don't know when the last time it had been calibrated?
No, sir, I do
You said, who makes sure that the machine is calibrated?
members from our traffic bureau, they handle the data master calibration as well as our teams and cities.
And to your knowledge, just to your knowledge, when was the last time that machine was calibrated?
Your Honor, I'm going to object to ask and answer.
Slightly different question. I'll do it.
To my knowledge, I do not.
You do not. So to your knowledge, you don't know if it's ever been calibrated, in all honesty, correct?
I know it has been calibrated. I do not know when the last time it was calibrated.
Does it have any like information on the machine itself to show when the last time this machine was calibrated? Is it like note on it or some kind of information that is documented on it?
I'm sure there are records that are kept on that by our traffic bureau, but that's not what it's regularly checked. On the display screen that is on the data master, if it is on there when it was calibrated.
Thank you. No further questions.
Anything else, Mr. Long?
No, Your Honor.
Sir, if the machine does in fact need to be calibrated, is there any notice that it gives you? Will it function at all?
To my knowledge, basically the test itself, if there's a large inaccuracy in the two results, then it won't be a valid test and it'll let you know the same. With this one, with receiving the same result of the 0.18 full claims, in my experience, that's something that is. Okay,
All right, thank you. Any questions based on my question?
Not from the people, Your Honor.
No, Your Honor.
Thank you, sir. You may sit.
No further witnesses from the people, Your Honor.
No, Your Honor.
People?
Your Honor, may I share my screen?
Yes. Your colors.
Your Honor, where can you sit? Because I want to sit.
Your Honor, we're looking at People's Exhibit 5, and it's about 28 seconds in. We first heard from Officer or Detective Schwab, who testified that these crossroads are Ryan and 8 Mile. The traffic coming towards this vehicle would be traveling east on 8 Mile, and Ryan is going north and south. We first heard from Jermaine Walker, who testifies that he's traveling northbound on Ryan, circling that in video. He's in a compass. We also heard about his injuries that he suffered because of this accident. We next heard from Moonmead Deb. She testifies that she and her family are traveling on Ryan Road. I'm circling on the video Ryan Road. She's driving northbound on Ryan. We also, there's been medical records that have been introduced for the Joy data and Franco data, and Terja data is the deceased. We next heard from Eli Thompson, the officer, who testifies that she speaks to the defendant at the scene. He states that he's traveling eastbound in his Malibu on 8 Mile. We also heard from Detective Richard Schwab that he made a determination that the defendant actually ran the red light, because when you look on the westbound of 8 Mile, the traffic light in the video is showing that he has the red light. We also see vehicles traveling on Ryan Road, not just Jermaine Walker's vehicle, but 2 other vehicles as well, that is traveling to indicate they have the green light as well. We heard testimony from the CDR report from the defendant that he was traveling 80 miles per hour, which is 40 miles per hour over the speed limit. And we also have People's Exhibit 4 and 7, which shows that the defendant's VAC, when it's converted into whole blood, as a result of 0.163. Your Honor, if I may, at this time, just play the video for 10 seconds, 20 seconds to 38 seconds. Thank you. I'm stopping the video at 38 seconds. Lastly, Your Honor, the court heard from 2 Dearborn Heights officers that a week prior, the defendant is in the same vehicle. He's driving intoxicated. He's swerving. He almost hits some kind of sign, traffic sign. He runs through 2 red lights. He drives the wrong way on the street. Your Honor, with that, in this case, again, he's driving intoxicated. He runs a red light. He's going 40 miles per hour over the speed limit to show that his intent, his actions are willful and wanton. He's doing the same exact thing the week prior. He knows that this engaging in this kind of behavior is dangerous. Yet a week later, he does the exact same behavior But this time it results in one person being deceased and 3 other individuals being severely injured. So with that, Your Honor, people are respectfully requesting that the court find over on all the charges.
All right, I have to correct myself, as I had said, that I didn't know anything about this case. That is clearly wrong, because we did take evidence, I think that was last week. And I remember this video and the testimony of the witnesses that testified. Mr. Tubbs.
No, I do believe this is a question of fact.
I agree, it is a question of fact. What I can hear your testimony of the witnesses that have come forth, as well as the same people's exhibit, is satisfied the people met their burden of probable cause as it relates to the charges contained in the court finds those charges were committed in the city of Detroit. The court finds probable cause to believe this defendant committed. Defendant will be bound over to Wayne County Third Circuit Court Criminal Division for proceedings. His arraignment on the information date and time will be April 25th, 2023 at 9:00 a.m. We continue. Now, his other matter, I think the reason that this here is because we want to keep these cases together. If I'm not mistaken. There was a co-defendant on that. Was that not?
Yes, McIntosh, Your Honor,
Yes.
he was bound over as well.
I think somebody working on information on this file.
That's all. That's.
Oh.
So I didn't have to bind up the. You only had that one.
Oh, okay, okay, all right.
That's what. No, you're doing a comp hearing on the day that doctors have to testify.
Oh, no, that was just. Thank you.
Thank you, John. You and your staff have a great day.
All right, you too, Mr. Tubbs.
Oh, wow.
Okay, Mr. Nasser, Ms. Drain.
Good morning, Judge. How are you?
Good, sir. How are you?
I'm doing all right, Judge. Judge, I thank you for allowing us to come in over Zoom. I am here on Stephen Negron. I would ask to waive his appearance, Judge.
Stephen Negron?
Yes, please.
Tomorrow?
Yes, Judge.
Yes.
Calling case number 2205927701. People of the state of Michigan versus Stephen Negron. Defendant is charged in count 1, malicious destruction of personal property, 1,000 to 20,000. Count 2, assault with a dangerous weapon. Count 3, reckless driving.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Your Honor. Good morning to your staff. May it please this most honorable court. Mohammed Nasser, P74485, appearing on behalf of Stephen Negron. Your Honor, I'd ask to waive his appearance for this hearing, please.
Or waive the defendant's presence. What's going on?
Judge, we are scheduled for exam tomorrow morning. And I apologize, Judge. I am out of the country. The anticipated return is the day following. And again, my sincerest apologies. I would have a teammate stand in. However, that teammate is covering a different matter that cannot be adjourned in Grand Rapids. So I'm respectfully requesting, again, my sincerest apologies to the court and of course to the fine prosecutor. One continuance, and I assure you I'll be present for that.
I understand the situation. When are you due back?
My intention is to be back Friday, Judge.
How about April 26th?
One moment, Judge. April 26th. We could do that, Judge, if this court would allow us perhaps at 11 or 11:30. I do have an exam scheduled at 10 o'clock in Inkster, so I can certainly make it for 11 or 11:30 if this court would allow.
Let's do April 26th at 11:30.
Thank you kindly, Judge.
And final, we continue. Prayers to you and your family.
Thank you again, Judge. Appreciate it.
So we can have those brothers.
Yes.
We see, what is that? It's a company.
You remember the doctor's supposed to testify.
Okay. We are down to 1:30, guys.
All right.
You know. Nice long ones.
Right. I'm gonna eat a salad.
Did they come in? He is downstairs.
Yeah.
I know y'all.
You coming back? You ready for the defendant?
I hope so. Like everybody's here.
Oh, okay. Right over here, sir. Ready for the floor?
All right. Mr. Hicks, are you there?
I am, Judge. I didn't realize Mr. Cripps is going to be there in person. Would you like me to come over to 36th District Court?
No, we might as well just go ahead and get this thing going. Calling case 2259294, people of the state of Michigan versus Devious Monta Weathers. Defendants charged in count 1, homicide, murder, first degree premeditated. Count 2, kidnapping. Count 3, weapons, carrying a concealed weapon. Count 4, police officer, fleeing third degree vehicle. Count 5, felony firearm. Appearances for the record, please.
Good afternoon, and may it please this honorable court, APA Jonathan Hitz, appearing on behalf of the people, P85288.
Good afternoon, Your Honor. David Cripps, P34972, appearing on behalf of my client, Mr. Devious Weathers, who is here in the courtroom. Tell the judge your name, please.
Devious Weathers.
Thank you.
Good afternoon, Mr. Weathers.
Good afternoon.
Good afternoon, Your Honor.
All right, so today is the time that we have set aside for a competency hearing, is that right?
Yes, Your Honor.
I noticed that we have 2 doctors here. Good afternoon, Dr. Abramsky and Dr. Hudson.
Good afternoon.
Good afternoon.
All right, are we ready to begin?
Yes, Your Honor. Defense says.
Okay, Mr. Hicks?
Yes, Your Honor. I believe it should be defense's witness since defense has the burden here.
I'm ready to go forward.
Okay, Mr. Cripps?
I did email the court Dr. Abramsky's CV.
You emailed it directly to me?
No, to Arnie.
Okay.
I did it a few days ago, but I just did it again.
All right.
So when the court's ready, I can start.
You can proceed.
Good afternoon, Dr. Abramsky. Can you hear me okay?
I can.
Okay. Could you state your name for the record, please?
Sure. Should I be sworn in?
I think you should be.
Sworn in?
Why don't you state your name? I asked the judges. For
Okay. Atara Abramsky. I'm a clinical psychologist in the state of Michigan.
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may proceed.
Thank you, Andrew. Yes, her name is spelled A-T-A-R-A. Last name is A-B-R-A-M-S-K-Y. Well, good afternoon, Dr. Abramsky.
Good afternoon.
Could you tell us what your professional status is now in terms of your degrees?
Sure. I have a PhD in clinical psychology with an emphasis on forensics, and I am fully licensed in the state of Michigan to practice psychology.
And where did you get your college degrees from?
I got my undergraduate degree from Oakland University and my doctorate from the California School of Professional Psychology, San Diego.
Okay. And how long have you been, would I refer to you as a psychologist then?
Yeah, I think I was fully licensed in 2007. I finished school in 2005.
Right. And you said fully licensed. Could you explain to Judge King what that means?
Sure. So I completed all of the requirements after I received my degree. I completed all of my requirements, my postdoctoral hours, and the 2 exams that were required in California, one being a state exam and one being a national exam. And by the time that was all said and done, I believe it was 2007, which allows me to practice psychology independently without supervision.
And you said you're fully licensed in the state of Michigan.
Correct.
And then the licensing as a forensic psychologist, what does that allow you to do?
It allows, well, I'm just licensed as a psychologist. It allows me to do therapy, to do testing and assessment, to testify in hearings, and write reports, things of that nature.
In relation to the issue of competency to stand trial, have you done previous reports on competency to stand trial in criminal cases?
I have.
Could you estimate how many for?
I would say over 20, less than 40, probably somewhere between, 20 and 30.
Have you testified in court before?
I have, not very often, but I have testified in court. This is probably maybe the 4th time I've had to testify in a competency evaluation.
Have you been qualified as an expert to testify before?
I have.
And have you been qualified as expert to testify regarding competency to stand trial?
Correct.
Your Honor, at this point in time, subject to any voir dire by Mr. Hitz, I would move to have Dr. Tara Bramsky qualified as expert psychologist to give the opinion of competency to stand trial.
Mr. Hitz,
Excuse me, Your Honor. No objection to having her as an expert in that regard. I would just reserve the right to ask questions regarding her qualifications during cross-examination.
All right, the court makes a finding that the witness may testify as an expert in the field of forensic psychology, is that it?
Yes, Your Honor. Dr. Abramsky, did you have occasion to be involved in a case involving a person by the name of Devious Weathers?
Yes, I did. I evaluated Mr. Weathers personally on 2/8/23.
And what was your purpose of your evaluation?
I was assessing him for issues regarding competency to stand trial with these current charges that he's facing.
And in order to do an evaluation such as competency to stand trial, how do you start out? What's the first thing you do?
So usually when I sit down with someone, I explain the nature of my visit. I explain some of the limitations to things like confidentiality, and I briefly outline with the client what we're going to be doing in the evaluation. I usually start by getting a history from them, things such as their family history, their work history, their substance abuse, mental health history. Then I ask them about their legal history, and then we talk about their current charges. I try to assess their account of the events and their level of accountability, and then I will specifically focus on issues of competency.
All right. In relation to that obviously required you to have a face-to-face meeting with Mr. Weathers, is that right?
I did.
And did you do that in this case?
I did.
All right. And you said that one of the things you look at is his past history. Is that right?
Correct. Correct.
Did anything remarkable stand out to you in terms of your conversations with Mr. Weathers about his past history?
Well, it did. One of the things that stood out was he wasn't a great historian. He had some trouble telling me things about his past, specifically dates, times. The other thing that stood out to me is he has a fairly significant trauma history. He was removed from his mother's care when he was very young and placed in the foster care system. Again, he told me he wasn't sure why he was placed in the foster care system. Initially, he said he could not remember being in foster care, but as we continued to talk, he was more disclosing and forthcoming with me. He shared with me that he had been physically abused in foster care, and then at one point indicated that there had been some sexual abuse, although he was very guarded and didn't want to talk about it. So that was something that stood out to me. And then from there, there were a lot of things from his past that stood out to me and that were notable for just sort of chronic poor adaptation, a lot of trouble in school, special education, difficulty with his academics as well as his social functioning, limited interpersonal skills and limited interpersonal relationships in the world. He was eventually returned to his mother, and he was able to forge a relationship with her. That was something that stood out to me, that at the time of his arrest, he was, he did have a good relationship with his mom. But mainly, if I had to summarize, I would say just a history of poor adaptation and trauma in his childhood.
You then talked about you went into his mental health history.
We did.
And is there anything significant that you think Judge King should know about regarding that?
Well, he has been treated for mental health in the past. As a child, his mom did take him places. I also spoke with his mother, and she confirmed a lot of this history. He did have one inpatient psychiatric hospitalization when he was very young. Neither himself nor his mother really knew specifically about his diagnoses other than ADHD and his learning disabilities and problems with academics and school functioning. But he did endorse a myriad of symptoms consistent with a depressive disorder. He's also experienced psychosis, and he's had intermittent treatment over the years.
What's a depressive disorder?
Depressive disorder is a disorder with symptoms that include sad mood, low energy, lack of pleasure in activities that normally bring one pleasure, anxiety, suicidal ideations. He did tell me that he had had suicidal ideations and had made some attempts at trying to harm himself in the past. And he had also said that when he was very depressed, he would have auditory hallucinations, a command in nature telling him to hurt himself, and that primarily happened when he was very depressed.
So he has attempted suicide in the past?
Yeah, I think he told me he tried twice and both times failed and never returned to it.
If you know, was one of those times of attempted suicide while he was in the Wayne County Jail?
No, not the ones that he told me about. He told me that he'd had 2 suicide attempts, one by overdose of pills and one by attempting to hang himself. And then he just said it never worked.
And could you explain to us what a psychosis is?
The psychosis would be the auditory hallucinations. These are voices telling him to do something to himself, harm himself. And again, he said he typically hears them in when he's very depressed, which is not uncommon if someone has a depressive disorder with psychosis, for someone to hear them when they are extremely depressed. He was not endorsing them at the time of our evaluations. He said he had not heard them in several months.
Did he tell you that those auditory hallucinations included command hallucinations?
So that's what a command hallucination is, voices telling him to harm himself. So yes, command in nature.
And in that regard, your report indicates he's currently being treated in the jail for mental health symptoms.
He is. He's taking, when I saw him in February, he was taking 2 medications, one of which is Seroquel. It's an antipsychotic, and the other one was Remeron, which is an antidepressant that's typically used mainly for sleep.
All right, you said you had a discussion with him regarding his current charges, is that right?
I did.
Anything remarkable stand out there that the judge should?
Well, he says he doesn't remember what happened that day. He said that he had drank quite a bit and had also taken Percocet, that he was not really able to recall it, but that he didn't think that he was guilty. My conversation with him regarding the charges, he just didn't seem to have the ability to discuss his thoughts and feelings with me in a way that I thought was very meaningful. And I wasn't sure if he was unable or unwilling to do that. He was able to recall certain events or to tell me about certain events that he had, maybe read from his discovery, and they were consistent with the police report. But the conversation I had with him about his charges was vague and, as I said, not very meaningful.
You said he doesn't remember what happened that day. What day was was that in reference to?
The day of the offense, he said that he doesn't remember shooting anybody, but he doesn't think he did it. He did tell me, I believe that he recalled, going to his father's house and the things that transpired in that house, which was as the records indicate, a standoff with police. And he did have some memory of that, but he said he doesn't recall shooting anybody, that he was drinking a lot that day, and that he'd taken Percocet, and he doesn't have memory.
Let me pivot to the area of testing. What kind of testing did you conduct with Mr. Weathers?
Yeah, so after my initial evaluation with him, I just had questions and concerns about his cognitive functioning. And that was for a few reasons, if I can share them. One was that he reported he was in special education as a child. He reported that he believed he was in a self-contained special education classroom. Typically, when people are in self-contained special education classroom, that means they have, in my experience, that they have severe learning disabilities or cognitive impairments. So I had some concerns about that. He said he has an ongoing poor memory, something that I experienced with him. And I had seen throughout some of the other records that I reviewed from his interviews at the Center for Forensics. And lastly was just his inability to really have a very meaningful conversation with me. I didn't see him as having a lot of insight. I thought his thought processes were very concrete. So subsequently, I decided that it would be appropriate to do some neuropsych testing with him. And that was done March 1st, 2023 by my psych assistant, Kirsten Toth, supervised by me.
Could you spell that name for the court, please?
It's Kirsten, Kirstin, and her last name is Toth, Toth.
Thank you. And was there anything significant from the neuropsych testing in this case?
Yeah, there were several significant findings, some consistent with his self-report. His IQ was noted to be in the extremely low range. I believe his full scale IQ score was 57. This indicated a mild cognitive impairment. He also was administered the RAT-5, which is an achievement test, meaning it measures more your academic skills, reading, writing, math. He scored very low on those as well. Lastly, he was administered something that we call the TOM. That's the test of memory malingering. And this is to see if people are feigning symptoms. Mr. Weathers did not do well on that test, which indicated that there was some deception perhaps on his part. So in totaling up all of the information that I had, we had to kind of try to piece together what we thought were I had to piece together what I thought were his true cognitive skills. And that's part of the reason I had a conversation with his mother. I should also add that we did the MMPI, which is a true false questionnaire that assesses more mental health issues not related to cognitive functioning or learning.
Your report indicates that he has an IQ score that puts him in the extremely low range of functioning.
Correct.
And did that factor into any part of your opinion as to competency?
Yes. I mean, again, his IQ score was very low. And that was sort of consistent with some of his history. He has an intermittent work history, for example. He has held jobs before, but they're jobs that involve simple and repetitive tasks. He's never had a driver's license. He's never lived independently, either living with family or girlfriends or being homeless. So the IQ is, and his academic skills were very low. So to me, and marrying those things are consistent with his sort of adaptive history. There's the two prongs of competency. I think Mr. Weathers, even from our conversation, was adequate when it came to describing the roles of participants, for example, in the legal process. He can accurately state the role of a judge or a jury. In that sense, he's competent. My concern, based on his intellectual functioning, is whether or not he can participate in his defense. And I have a lot of concerns about him sitting in a trial and being able to keep up with what is going on, reading legal documents, understanding. I believe his comprehension is poor, and also he is slow to comprehend things. So those were my primary concerns related to competency. Is, will he have to just blindly follow his attorney's advice, or will he really be able to weigh choices and consequences and fully understand what's going on in a trial?
In that regard, I see your report indicates that his intellectual impairment appears to be affecting his practical domains of functioning with challenges.
Mm-hmm.
which could relate to complex tasks such as his current legal situation?
Right, and that would be reading documents, keeping up with what's going on, the motions, the, the witnesses, all the legalese. I'm not convinced that he's able to do that, based on his level of functioning.
And so that led you to one part of your report on page 8 that I see that says, you believe that Mr. Weathers is not able to function in the legal process adequately in preparation for his defense.
No, and that's based on what I found in the cognitive testing, what I saw of him in his interview, his sort of report, and even some of the things that I've read that he said before, like when you ask him about strategies, he might say something like, we need to work it out. Well, yes, that's true. He can say that, but how he would go about working out his legal issues with his attorney, I think is above his ability.
In your report, you made a finding that he suffers from mild intellectual disability as part of your diagnosis. Is that correct?
Correct.
And secondly, as you explained earlier, he suffers from major depressive disorder with psychotic features, including controlled in part by medication at this time.
Correct. When I spoke with him, I mean, he was definitely depressed and he's unhappy about his situation. I found him to be dysphoric, but I didn't see his mental health issues as something that's significantly impacting his functioning at this time.
Now, based on all this, Dr. Ramsey, did you reach an opinion in relation to Mr. Weathers as to whether he currently is competent to stand trial?
Right. So I don't believe that he's competent. I have concerns about his ability, as I said, to function in the legal process. I did weigh all the evidence, and I know there's some inconsistencies in his presentation and his performance, in his overall presentation that I observed versus what I read in records at times. So I did take all of that into account, also his mother's report of his history, and I did take that all into account. And I still do believe that he would struggle with participating in his defense in a rational way.
In reaching your opinion that Mr. Weathers is not currently competent to stand trial, did you reduce your findings and opinions to a report?
I'm sorry, I didn't understand the question.
Did you prepare a report in this case?
Oh, I did. I prepared a report.
And that's a 10-page report?
Yes.
All right. Your Honor, I have marked as defense proposed Exhibit A, the Dr. Ataro Bramsky's 10-page report regarding Mr. Weathers and his status of being incompetent to stand trial. I would now move for submission for the purposes of this hearing.
Any objection?
No, Your Honor.
Admitted.
Thank you, Honor. With Dr. Bramsky's testimony and the admission report, I have nothing further.
All right. Cross-examine, Mr. Hicks.
Just one point of clarification. I heard Mr. Cripps indicate that he provided Dr. Abramski's CV to the court. Is that being moved for admission as an exhibit?
Yes.
Thank you, Mr. Provider. I move for submission. If I did or didn't, I move for submission.
Admitted.
Thank you.
And is that just defense exhibit B?
Yes, both her report and the CV will be marked as A.
Understood.
Mr. Hicks.
Thank you, Your Honor. Dr. Abramski, I'm going to ask you a series of questions. If you don't understand my question or you have difficulty hearing me, please just let me know.
Sure.
I apologize. I am having some difficulties with my voice due to the weather change that we're going through in Michigan here.
I can relate. I can relate.
Well, I appreciate that. So if you can't hear me at any time, just feel free to ask me to rephrase. If you answer my question, we'll just assume that you understood the answer. Does that make sense?
Sure.
I want to start by asking you just a few questions about your training. Do you have any formal training in the area of forensic psychiatry?
Well, I'm a psychologist, not a psychiatrist. But as far as forensic psychology, I have an emphasis from my graduate program on forensics, which means we took specific classes geared towards forensic psychology. Other than that, no, I would say I don't.
Okay. What about any certifications in the area of forensic psychology?
No.
Do you have any formal training on the Michigan legal standard for competency?
Formal training, no.
Okay. What about any certifications regarding that standard?
Nope.
And you said you've evaluated competency, I believe, 20 to 30 times?
Probably. Yes.
And that resulted in your testimony in court about 4 times, or this will be the 4th time?
I think this is maybe my 4th time having to testify.
So you've testified 3 times previously?
Correct, that I can think of.
And you said no court has ever refused to certify you as an expert, isn't that correct?
No, they have not.
And in those 3 competency hearings that you testified in previously, did you testify in favor of a finding of competence or against competence? What was your conclusion reached in those 3 prior proceedings?
So my conclusion was that they were not competent.
In all 3 of those prior proceedings?
Correct.
And what about the conclusion that you reached in those 20 to 30 reports? Can you provide just an estimate of the number of times that you found a defendant incompetent versus competent?
Yeah, so what I will say is that I think the bar for competency is pretty low. So I typically, I would say more than 50% of the time, find people competent. I would say if I've evaluated 30 people, I've probably found 10 incompetent and 20 competent, but I am just sort of ballparking these. I can't say for certain.
Completely understandable. That's all I'm asking for is a ballpark figure, and I appreciate that. So your ballpark would be out of those, if you did 30, 10 would be incompetent, 20 would be
Maybe 7 to 10, I would say.
You mentioned his treatment for mental health issues. This is Mr. Weathers specifically I'd like to talk about now.
Okay.
I think you described his treatment as intermittent. Is that fair?
Yes.
Fair to say that he's been treated outside of a incarceration setting only intermittently?
Yes. Starting in childhood.
And yes, going all the way back to childhood. And you mentioned that he had difficulty discussing the charges with respect, or excuse me, the exact circumstances regarding what occurred with the underlying conduct at issue here.
Yes, he said he doesn't have any memory of shooting anybody.
But he said he was drunk and was on other medications at the time.
He said he was drinking large quantities of alcohol and he'd also taken Percocet that day.
And doing those types of things, drinking large quantities of alcohol while consuming Percocet, that could impair your ability to remember. Isn't that fair to say?
It could.
And it could cause your memories of an event to be pretty vague.
Yes.
And that would not necessarily weigh on your competence to aid and assist in your own defense now that he's presumably not drunk or on those other medications.
No, competency is sort of an issue of here and now. So I was basing it on the here and now, not having anything to do with what he told me about his crime.
And in your evaluation, did you review school records?
So I attempted to get his school records. I have yet to get them. This hearing came up and I don't have his school records. The only things I reviewed from his school records were in the report prepared by the Center for Forensic Psychiatry. They summarized some of his school records. And so that was all I was able to get. I'm still sort of in the process of trying to get those records, but for the sake of time, we didn't get them. I didn't get them.
So it's fair to say that as of now, you haven't reviewed them.
No, all I have seen is what the examiner from the Center for Forensics summarized.
And aside from the psychological testing that you oversaw, did you review prior psychological testing that was completed on Mr. Weathers?
No, I wasn't able to review any.
What about prior intelligence testing?
No.
And you diagnosed the defendant with a mild intellectual disability, is that correct?
Correct.
And you also diagnosed him with major depressive disorder with psychotic features?
Correct.
But you noted that that was at least partially controlled by medication?
Yes, as I said, I don't believe his mental health symptoms were a primary issue. When I saw him, he wasn't hallucinating. He was reporting accurately what he was feeling, but I didn't feel that his mental health issues were impairing his ability to function at the time that I saw him.
And when you initially interviewed defendant, I want to start by talking about, you've described it as two prongs of competency. With respect to that first prong of competency, when you started asking him questions about the criminal justice process, he initially told you, and I'm going to quote, "I don't get this court shit."
Correct.
And once you actually started asking him specific questions regarding the process, he started to provide answers to those questions.
Yes, and he does get a lot of it, I think,
So
on a simplistic level.
But he correctly identified the role of the defense attorney.
He did.
And he said, my job as a prosecutor was to find him guilty.
He did.
And Judge King's job was to sit back and listen to it all.
Correct.
And he was able to accurately interpret some of his Miranda rights.
He was.
And he identified that a plea agreement would be less time than his initial charge.
Yes.
And he couldn't describe the exact differences between first and second degree murder. Isn't that fair to say?
No, he couldn't. But when I worked with him and talked a little bit about them, then he was able to, have a conversation with me about them and state some things that were accurate.
And he knew that first degree murder was worse than second degree murder.
Correct. Like I said, it's sort of he has a simplistic but accurate perception of the roles of people in the legal process.
And that first degree murder would result in a longer sentence if he was convicted of that crime?
Yes.
And your specific opinion with respect to that first prong of competency is that Mr. Weathers is able to adequately understand the criminal process and the role of the participants, even though it's in a simplistic manner?
Correct.
And you noted that there are things that he did not know, but he appeared to have the capacity to grasp them, at least on a basic level.
Yeah, I sort of relate that to how I kind of worked with him on the difference between first and second degree murder, and then he starts to understand it. I do believe he has that capacity.
And you evaluate the defendant's ability to function in the legal process primarily through consulting with defense counsel in the preparation for his defense?
Correct.
And this is the prong where you think he would struggle if this case proceeded to trial?
This is the prong where I had concerns, correct.
And it's fair to say that your concerns with respect to this prong relate to his intellectual capacity and not the major depressive disorder?
Correct. I will say that I think the two things can interact, and that can impair his functioning even more, makes him a bit more vulnerable. But again, when I saw him, I don't believe that his depressive disorder was affecting his functioning. Not to say that it wouldn't if he was having a depressive episode.
But at least with medication, that appears well controlled.
It does.
And the intellectual capacity is really the part of the issue here, in your opinion?
Yeah, the intellectual capacity, and then his achievement scores indicated he was functioning at a first and second grade level for things like reading and writing. That was also a concern.
I understand. And during your testing on, we'll get to the specifics in a minute here, but is it fair to say that generally it appeared he wasn't putting forth good effort on a number of the tests he was tested on?
I think that his effort was not full. So the way that I conceptualized his effort level was not necessarily that he was intentionally doing badly, and I can explain why in a minute, but that he was very anxious. And in fact, when going over the raw data, it was written in the margin, like, his effort seems poor, but it seems that he's getting overwhelmed. So the idea was that, for example, the minute he saw something, he would say, I don't think I'm gonna be able to do that. And then he would do it with prompting, but that he was overwhelmed, and that when he didn't know something, he wanted to give up easily without trying really hard. I don't necessarily think that was him feigning or faking or trying to intentionally produce bad results. I think it was more that he was overwhelmed by it and didn't feel that he had the capacity to do it well, so he didn't want to try. That's what, I spoke with my examiner and the two of us together. That's sort of what we concluded that we thought was going on with him at the time of testing.
So I'm a little bit confused because in your report in response to those issues, you note that in the criminal justice process, there is the possibility that exaggerated presentations can commonly occur when this type of testing takes place.
It can, yes.
So rather than you believing that this is an exaggerated presentation, you're now saying that you believe that it's simply him being overwhelmed with the process?
Well, I mean, I think it could be either of those things and a combination of both. I mean, to get overwhelmed or to make sure that he's getting his point across that he really struggles with something, you know, in an attempt to get that point across, he could be becoming overwhelmed. So, you know, these were just sort of hypotheses of why the results came out the way that they did, why he did so poorly on the TOM. And, you know, again, I can't say for certain because I'm not in his head, but these were just some of the ideas that I thought could possibly be going on with him at the time.
Can you point us to any studies that support that conclusion regarding the exaggeration that might be shown on these types of tests?
No, that's more just based on my experience. My experience has been when people are really just faking, their presentations are ridiculous, very unbelievable, and everything is extremely poor. Whereas with someone like Mr. Weathers, we saw some inconsistency. He did well on some subtests of the IQ. He scored a 7 on block design. That's in the low average range. If he was completely faking, I wouldn't expect to see a score of 7 on the subtest of block design. We would expect to see very low scores on everything. So again, that was part of the reason I drew that conclusion. And this is based on my experience.
You would agree with me that testing that takes place outside of legal circumstances, that type of exaggeration is less likely to be shown?
Yes, of course.
And you noted he struggled with decision-making in your report?
Yes.
It's fair to say that a large number of individuals that find themselves charged with crime struggle with decision-making?
Sure.
And another basis for your conclusion is your belief that he couldn't keep up with what's going on in a courtroom if he was to sit through a jury trial?
Yeah, I think that would be very difficult for him.
He would have difficulty understanding the legalese.
Yep.
You mentioned.
Yep, the paperwork, the objections.
You met with them on 2 separate occasions, isn't that correct?
I met with him once, and then my psych assistant did the testing on a second occasion.
Okay. That one time you met with him, his affect and mood were congruent?
Yep.
And his speech was coherent?
Yes.
He was oriented to surroundings?
Correct.
He did not display any psychotic symptoms?
Correct.
There were no noted delusions that he harbored?
Correct.
And no noted bizarre thought contents?
Correct.
And he performed adequately on a mental status exam?
He did, for the most part, he did perform adequately on the mental status exam.
And is it Dr. or Miss Toth? I'm sorry, your assistant?
Miss Toth.
So she performed a psychological and neuropsychological assessment?
She administered the neuropsychological battery. And then she also, when we gave him the MMPI, which is a true false, she read the questions to him because his reading skills were so low.
And she reported that his effort during the evaluation was very poor?
She questioned his effort, yes.
But she noted he was cooperative.
Yeah.
And socially pleasant.
Yes.
And that he spoke with a typical rate, volume, and prosody.
Correct.
And I want to talk about some of the testing she administered. She administered the Welsher Adult Intelligence Scale, 4th edition.
Correct.
And that measures full scale IQ.
Correct.
And it's fair to say that IQ is stable throughout an individual's lifetime.
It should be stable without the absence of like a significant trauma or other variables that can lower someone's IQ. But minus those things, it should be fairly stable over time.
Do you know of anything in Mr. Weathers' history that you would expect to lower his IQ?
You know, the only thing that I could think of was there was some pretty significant alcohol abuse. I mean, that can at times impair somebody's cognitive functioning in the long term. He also has a history of trauma, and trauma can impair somebody's cognitive functioning, especially when it happens in childhood. Those would be the 2 things that I would worry about affecting his IQ.
And she administered a wide range achievement test.
Correct.
And he performed in the extremely low range across all subject areas.
Correct. It was a word reading, spelling, and math, and he was in the 1st percentile with a grade equivalent of roughly 1st grade.
in all those functional areas, was it essentially first grade level?
Correct.
Would you expect someone to have extremely poor performance in a classroom in school if they had performed at the level tested on the wide range achievement test here?
I would expect them to have poor performance. I would expect special education placement. Yes.
And if that poor performance wasn't noted in their academic record, would that be evidence that they might not have been putting forth adequate effort on the wide range achievement test?
Yes. If they had no special education placement in school and there were no noted difficulties and they received good grades, these will all be things that I would look at and perhaps attribute it to poor performance.
And are you familiar with the validity indicator profile?
For what test?
For either the wide range achievement test or the Welsher Adult Intelligence Scale 4th edition?
I don't believe there is a validity indicator for the WAIS.
Okay. Just generally speaking, would it be fair to say that a validity indicator measures, are you familiar with validity indicators generally?
Generally.
And there are tests that measure whether an individual is putting forth adequate effort?
Yes, I'm more familiar with that in relation to like personality tests, as far as somebody being honest in their approach to the test taking and whatnot.
And you don't know of any validity indicators that could have been administered alongside the wide range achievement test or the Welsher Adult Intelligence Scale test?
I don't, no. That's one of the reasons we administer the TOM.
And the TOM is the test of memory malingering?
Correct.
And what is malingering?
Malingering would be feigning symptoms.
And why do you test for it?
Well, we think it's important to try to get an accurate picture, a clinical picture of somebody if there are reasons that they might be faking. And again, especially when testing takes place under legal proceedings and there is a greater tendency for somebody to perhaps exaggerate their symptoms or fake them completely, given the circumstances.
And on that TOM, Mr. Weathers scored below what would be expected by chance. That's fair to say.
He did.
And on trial 2, his score was 27 out of 50.
Yes, much lower than we would expect for somebody that was, participating effortly and honestly.
And that score that you would expect is at least 45 on trial.
Yeah,
2.
it's yes. I mean, the TOM, even people with traumatic brain injuries can do fairly well on a test like the TOM.
So that's indicative that he was at least exaggerating his memory impairment.
Exaggerating it or not putting forth effort. Yes.
And you also performed, or I'm sorry, your assistant performed the Minnesota multiphasic personality inventory.
Correct.
And overreporting was indicated by that measure.
Correct. And that is where I think I typically see that exaggeration of symptoms to try to get their point across of how well they're not doing. And sorry, go ahead.
And just to clarify what overreporting means there, the report that he provided would be uncommon, even in individuals with genuine severe psychological difficulties. Isn't that fair to say?
Yes, overreporting, endorsing, a variety of symptoms in an atypical fashion, perhaps, or, endorsing the majority of symptoms without discretion.
And could this be further evidence of malingering?
It's possible.
And did you perform the inventory of legal knowledge test?
I did not.
Are you familiar with that test?
I am.
You'd have no reason to dispute the findings of Dr. Hudson on that test?
No, and I read that report. I think that was consistent with what I had said, is that he does have knowledge of the legal process.
Thank you.
Mm-hmm.
And just for clarity, the testing that we've just discussed, any of the testing, none of that was designed for application specifically in the context of evaluating competency as defined by Michigan law?
No.
I have no further questions. Thank you, Doctor.
Mr. Cripps, anything else?
No, Your Honor.
Doctor, I have just a few questions for you.
Sure.
Sounds like your primary concern with the defendant is his ability to assist in his defense in terms of understanding and helping with or understanding the legalese used in the courtroom, the objections and that type of thing. Is that right?
Yes, that, and I would say the critical thinking that is needed to, weigh options, proceed in legal hearings, and that's just the overall comprehension of what's going on in a courtroom. That's hard for any layman, including myself.
That was gonna be my next question. You're not suggesting that he perform at the aptitude of a law student or college student, are you?
I'm not, no, but I will say, like, even for myself, sometimes it's hard to understand, just keeping up with, objections. And, I can only imagine there's a multitude, a voluminous amount of paperwork and motions. And, it's a lot for, the average person. And then you take someone with him and his past and his history of poor adaptation.
That's why we get real skilled attorneys like Mr. Cripps to represent us, right?
That's right, but if he can't comprehend it, I'm not sure how, Mr. Cripps, as good as he may be, will help him comprehend things that he's struggling with. I think that would be a very big challenge for his attorney.
I think I also read, or maybe I'll oversimplify things a bit. You said something along the lines as you talk more about the specifics of the case, his impairment became more prevalent. Would that be fair to say?
Can you explain the question a little bit more to me, Judge?
If you ask specific questions about the charges that are lodged against him, that's when he seemed to get more confused or unable to participate in the process.
Well, yes, in part because he says he doesn't have memory of it, but I think the more specific you get about legal issues with Mr. Weathers, the more confused and the more unable to participate he will be in general, including his case or any hypothetical case.
You say legal issues, are you talking about something fact specific as it relates to his case or generally speaking?
No, I'm speaking generally. The facts of his case, it's hard. He says he doesn't remember, so it's hard to speak on, his ability to talk about the facts of his case.
You note in your report that Mr. Weathers' performance may be indicative of exaggeration of memory impairment.
Correct.
Would you agree that being charged with first degree murder may be a motive in trying to be that deceptive?
I believe it is a possibility. It's certainly, obviously I reported it and it's something that I have taken into consideration. And
ask you this, if you feel that he may have been malingering in some portions, why not that he's trying to be deceptive or feign in other areas of the test? Why wouldn't that be consistent?
So I'd like to just explain a little bit. I don't think he's malingering. I think that at times he was lacking effort and that he may have been exaggerating. So what happens oftentimes in situations like this is let's say his IQ score, we yielded a full scale IQ score of 67 or 57, right? So if he's exaggerating his symptoms or not putting forth effort, maybe his full scale IQ score is really a 65. That doesn't mean he doesn't have an intellectual impairment. Is there secondary gain from, faking these symptoms? Possibly. He just didn't present as somebody that I typically find that's malingering. I mean, I have had people tell me in mental status exams, one question we often ask is, how are a piano and a drum the same, for example? And I've had people say to me, I don't know what those are. Those are the kind of things that really raise a lot of red flags that they're just completely faking. So that's why I just want to make a differentiation between perhaps exaggerating or not putting forth effort, one of those two, and completely faking his symptoms. I agree that he wasn't putting forth effort and may have been exaggerating, but I don't believe that means he doesn't have these impairments. And I believe that his history, although his school records are inconsistent, and I believe that his history kind of supports this idea, he has struggled with poor adaptation all of his life, and his history is.
You have reviewed his school records?
So the only records I was able to review were the ones that were documented in the Center for Forensics report. And what I saw was inconsistencies. At one point she documented that in 2002, he had a low average. And then in 2005, there were areas that were in the extremely low range. And he did have a special education placement for speech impairment and learning disability. So, given those things, that's one of the reasons I would do the testing, is to see for myself, what information I could get by doing the testing ourselves.
Let's be clear, special education doesn't mean that you're, for lack of a better term, and I don't know if I'm being politically incorrect here, doesn't mean that you're retarded, right?
No, it doesn't mean you have an intellectual disability, is what we say now. And it doesn't mean that at all. There's what's that?
Okay, thank you for correcting me.
Sure. And so it doesn't mean that. And so, we usually see the below 70 IQ designation in school as he would have a cognitive impairment, which was not shown in the records. It just said a specific learning disability. But I do disability evaluations for the state of Michigan, and I often test kids that are designated specific learning disability. And then when I test their IQ, it is below 70. His school records are just inconsistent. He was also a very big behavior problem. So again, this is why we did testing, and is to get this information ourselves.
Do you believe he has a rational and factual understanding of these proceedings?
I think he would struggle with the overall comprehension in these proceedings. I think that he gets some of it, but I don't know that he necessarily gets it all. I think he would struggle. And again, in the pace of a courtroom, I would be concerned. And again, this is a murder trial. There are a lot of, there's a lot at stake. And so I would be concerned that in a trial where the consequences are so severe, he would struggle with the comprehension of what was going on. In this proceeding, I'm not sure if he's able to fully grasp it, but I don't necessarily think that he has a full range of understanding of what's going on in a timely fashion.
Are there any questions based on my questions?
No, Your Honor.
No, Your Honor, thank you.
Thank you for your time, Doctor. Appreciate you.
Sure. Do you want me to stay on? Do you want me to get off?
I would have no objection to her leaving the hearing, Your Honor.
Mr. Hicks?
No objection, Your Honor.
Okay, you're all good. Thank you.
Thank you.
Thank you, Doctor.
Yep, thanks.
Okay, Mr. Cripps, anything further?
No, Your Honor, thank you.
Mr. Hicks?
Excuse me. Yes, Your Honor. The people called Dr. Brooklyn Hudson.
Doctor, please spell your name for the court reporter.
Yes, it's Brooklyn Hudson, Brookelyn, Hudson, Hudson.
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you very much. You may begin when you're ready.
Thanks, Judge. Just one quick question before I get started. I did email in 2 exhibits to Arnitha that I plan to use during the course of Dr. Hudson's testimony, just her CV and her competency report. I was just planning on putting them on the screen for identification purposes and then relying on the versions that I sent in to Arnitha, if that's okay with you. Okay, thank you. Good afternoon, Dr. Hudson. Could you please state your name again for the record?
Yes, good afternoon. It's Dr. Brooklyn Hudson.
And how are you currently employed?
I'm currently employed through the state of Michigan at the Center for Forensic Psychiatry.
And what's your title?
Forensic psychologist.
And how long have you worked in that capacity?
I've worked since August of 2022, August of last year.
And what are your duties in that role?
My duties are administering competency and criminal responsibility evaluations, as well as providing inpatient treatment services to a group of patients here at the center.
Do you have any particular training or experience that helps you in that role?
Yes, so with regards to my education, I have my doctorate degree in psychology. And I've gone through a significant amount of training and education related to clinical psychology, and as well as emphasizing in forensic and correctional issues.
Why don't we talk a little bit about your education? Prior to achieving your doctorate, did you achieve any other degrees?
Yes, I achieved my master's in clinical psychology, and then prior to that, I achieved my bachelor's in psychology.
And what institutions did you achieve those from?
I earned my bachelor's at Cedarville University in 2013. I earned my master's in clinical psychology at Spalding University in Louisville, Kentucky in 2016, and then my doctorate in clinical psychology through Spalding University as well in 2020.
Prior to joining the Forensic Center, did you have work experience in the same field?
Yes, I had work experience actually within the Department of Corrections, providing therapy and assessment services as a psychologist to a male inmate population.
And what were your duties in that role?
Providing psychotherapy, providing intake and assessment services with the inmates, conducting psychological testing, writing psychological reports, conducting crisis interventions, providing crisis therapy intervention with the inmates, as well as occasionally conducting sex offender risk assessments or parole board evaluations for the courts.
Any other relevant work experience?
Yes, throughout my education and training, I had the opportunity to provide therapy and assessment services within an outpatient mental health treatment setting, within inpatient hospital settings, as well as within other various correctional and forensic settings.
Are you licensed in any relevant capacity?
Yes, I am fully licensed as a psychologist in the state of Michigan.
And how long have you held that?
Since January of 2022.
And what steps are there for you to become licensed?
So once I obtained my doctorate degree, I completed a postdoctoral internship, completing those postdoctoral hours under supervision by another licensed psychologist. And then I completed the national examination for psychologists.
Are you certified in any particular capacities that it's relevant?
So I am currently, since my hiring at the Center for Forensic Psychiatry, I am undergoing the certification process to become a consulting forensic examiner, and actually will be certified within the next month.
And what are the steps for obtaining that certification?
So the steps include attending various didactic lectures on core forensic material, as well as observing a number, I believe it's 7 competency evaluations and 5 criminal responsibility evaluations, and then conducting my own competency and criminal responsibility evaluations under the supervision of another licensed psychologist or consulting forensic examiner. And then completing what's called a mock trial, participating in that.
So that's a certification specific to forensic psychology?
Yes, it's a certification process specific to forensic assessments. Yes.
And with respect to forensic psychological assessments that you've completed, it sounds like with the supervision of others, how many have you completed at this stage?
I've completed 10 competency and 10 criminal responsibility evaluations.
And during the course of those evaluations, what has been your conclusion in those 10 instances of competency evaluation?
For competency, I believe I have opined 8 out of the 10 were competent to stand trial, while 2 I opined were incompetent.
And have you previously testified as an expert witness?
No, I have not. This is my first time.
I'm gonna put something on the screen for you. which I had previously marked as People's Exhibit 1. Actually, I need permission from the court to share my screen.
Yeah.
Okay. Can you see that, Dr. Hudson?
Yes, I can.
Do you recognize this document?
Yes, that is my curriculum vitae.
And is this a fair and accurate summary of your qualifications?
Yes, looks correct.
At this time, I'd move to admit what I previously marked as People's Exhibit 2. I'm sorry, I think I previously referred to it as People's Exhibit 1.
No objection to the admission of Exhibit 2.
Admitted.
Thank you. And at this time, I would move to qualify Dr. Hudson as an expert in the field of forensic psychology.
Mr. Crooks.
Briefly, thank you. Good afternoon, Doctor.
Good afternoon, Counselor.
Your report says Dr. Brooke Hudson. I assume Dr. Brooklyn Hudson is your complete name.
Yes, that's correct. Dr. Brooklyn is my full legal name, but I often go by Brooke. Yeah.
Thank you, Doctor. You said that you've been at the Forensic Center for how long?
Since August of 2022.
Since last year then, is that right?
Yes, correct.
And you've been licensed as a forensic psychologist for how long?
So I'm currently licensed as a clinical psychologist since January of 2022.
All right, so in terms of forensic evaluations, how many would you estimate you've done since you've been at the forensic center?
Since I've been at the Forensic Center, I've completed 10 competency evaluations and 10 criminal responsibility evaluations.
And of those 10 competency evaluations, how many did you find the person to be competent to stand trial?
I opined 8 out of the 10 to be competent.
And you said you've never testified in court before regarding the issue of competence to stand trial, is that correct?
That's correct.
And therefore, obviously, never have been qualified as an expert before to give an opinion at competence to stand trial.
Correct.
I don't have any further questions, Judge.
Okay, Mr. Hicks.
I had moved to qualify her as an expert, and I don't think Mr. Cripps has stated his opinion on that.
Well, I have no objection, obviously.
Okay. Court will make a finding that the witness may testify as an expert in the area of forensic psychology.
It needs to be a first time forever expert, right, Judge?
We all have to start somewhere, right?
Thank you.
First, Ms. Hudson, Dr. Hudson. Mark that down on your calendar.
And you evaluated a Mr. Devious Weathers for his competency to stand trial?
Yes, I did on November 18th of 2022.
And just for the record, can we stipulate that that individual is the individual sitting in the courtroom behind Mr. Cripps?
Oh, I'm prepared. I'm prepared to enter that stipulation as long as the doctor is.
Noted. I can put a close-up on Mr. So as I find the note.
It's definitely Mr. Weathers.
Just want to make sure this is the person that you evaluated, Doctor.
Yes, I'm just waiting for the camera to show bigger. But yes, I did see him earlier, and that is the individual I evaluated.
Okay. Noted.
And you authored a report regarding your opinion that you derived from that evaluation and other sources?
Yes, I did.
Permission to share my screen again, Judge?
Yeah.
I'm showing you what I've previously marked as People's Exhibit 1. Do you recognize this document?
Yes, I do.
And what is it?
That is the competency report that I completed. after my evaluation of Mr. Weathers.
At this time, I'd move to admit People's Proposed Exhibit 1.
No objection to the admission of one, Your Honor.
Admit it.
What sources of information did you use to evaluate Mr. Weathers' competency?
So prior to the evaluation, I reviewed the court orders for competency and criminal responsibility evaluations. I reviewed the police report and the warrant felony. I had brief telephone consultations with both the prosecuting and defense attorneys. And then I completed a 2.5-hour evaluation with Mr. Weathers. And then I also later reviewed previous medical and school records, as well as results of psychological testing administered to Mr. Weathers on November 18th at the time of the evaluation.
And just let me unpack that a little bit. That prosecuting attorney you spoke to, just for the record, that was Abigail McIntyre, the former prosecutor on this case?
That's correct, yes.
And the defense attorney you spoke to, that was Mr. David Cripps on the Zoom?
Yes, correct.
And the school records you reviewed were from the Detroit Public Schools and Hamtramck Public School?
Correct.
I'm not sure you mentioned this. Did you also review Wayne County Jail records?
Yes, that's what I meant via the medical records, but yes, mental health records from Wayne County Jail.
Is that referred to as NAF care?
Yes.
In your report, you note that you reviewed the evaluation photo sheet. Is that correct?
Correct, I did. That was something that's completed with all defendants when they arrive at the Center for Forensic Psychiatry. So I did review that.
And what is it?
It's a picture of the defendant that's completed during their processing once they arrive for their evaluation. It includes various demographic information, such as obviously their name, the criminal charges that they're facing, their weight, their height, their race, their ethnicity, their gender, things like this.
What about the evaluation services questionnaire?
So that is also another questionnaire that's administered to defendants when they arrive at the Center for Forensic Psychiatry. It's completed by the defendant, and it includes questions, again, demographic questions about their age, their date of birth, their previous address, I believe it asks questions related to like their family, like their parents' names, if they have any children, education history, as well as previous mental health, any previous mental health or medical treatment history.
And I don't know if you mentioned this specifically, but did you also administer the inventory of legal knowledge test?
Yes, so that was actually administered by a master's level psychologist here, Miss Dana Kinnelly, on that day of the evaluation.
And what is that?
So the inventory of legal knowledge is a response style measure. So in other words, it measures how the individual approaches the test. It kind of measures whether they're putting forth effort, whether or not they're not really putting forth effort, whether they're motivated in their testing efforts.
And I want to jump ahead to your meeting with Weathers. Prior to meeting with Weathers, it sounds like, Mr. Weathers, it sounds like there was an intake process that took place at the Forensic Center?
Correct.
And do you receive reports from staff regarding how that process proceeded?
Yes, we typically receive verbal reports from evaluation unit staff, and they did provide a brief verbal report that day to me, indicating that Mr. Weathers was calm, he was cooperative, there were no issues observed during his processing.
And what did you specifically observe when you met with him?
So I met with Mr. Weathers. He was very calm. He was polite. There initially was some guardedness in his presentation. In other words, he was somewhat hesitant to initially answer questions related to his case, related to general competency questions. often responding, with answers like, I don't know, or I have no idea. However, as the evaluation progressed, Mr. Weathers did become much more open. He appeared more comfortable and appeared to be much more forthcoming in our conversation.
How was his grooming and hygiene?
His grooming and hygiene appeared adequate. I did not note any significant impairment or issue with that.
Did he make any representations regarding his ability to read?
I'm sorry, could you repeat the question?
Did he make any representations to you regarding his ability to read?
So he did initially. So at the start of every evaluation with the defendant, I'll go over what's called the advisement, where I will discuss, limits to confidentiality, the purpose of the evaluation, things like that. And typically we have the defendant read over it. However, Mr. Weathers did state that he didn't read so well and he didn't really quite feel comfortable, didn't want to embarrass himself by reading. So because of that, I did just kind of go over the evaluation or the advisement form with him and reviewed that with him.
Did you see any indications of a thought disorder?
I did not.
How was his orientation?
He appeared very alert, very oriented to time and place. He was aware that he had come from the Wayne County Jail. He was aware of the date. And he otherwise presented as very clear and coherent in his thought process.
How was his speech?
His speech was of normal rate, rhythm, tone, volume. I did not notice any significant impairment or issues with his speech.
Did he express any bizarre beliefs or experiences?
He did not.
What about any strange thoughts, delusions, or hallucinations?
No, none that were reported by him or observed in our conversation by me.
Did you observe him responding to any internal stimuli?
I did not. He appeared focused. He did not appear distracted or as if he were looking off, being distracted by something like internal stimuli or hallucinations. He was focused.
What about his mood? Did he demonstrate any signs of a manic mood?
No, I would not say he demonstrated any signs of a manic mood. He did demonstrate some mild depression. This was evidenced not only by his own self-report of feeling depressed, but also by some limit in his emotional expression, as well as a period of tearfulness while discussing his case. But all of this appeared very appropriate to his current legal situation and circumstances.
Did he report any issues with respect to his sleep or appetite?
He did note that he'd been having trouble sleeping and had decreased appetite since being incarcerated.
Did he report any weight loss?
He did not. He said he did not notice having had lost any weight.
What about his energy level?
He actually reported his energy level to be good.
What about suicidal ideation?
He did indicate a history of suicidal ideation. He also noted that actually just in the few days leading up to the evaluation while in the jail, he had experienced suicidal ideation and actually attempted suicide via hanging. In our discussion of that, he said he kind of started to proceed with the suicide attempt, but then stopped himself and later spoke with another inmate. And after speaking with that inmate, later determined that that was something that he did not wish to go through with.
Did he identify any specific reason that he didn't want to continue with his suicide attempts?
Yeah, he said he came to the determination that it would be selfish, and he identified his family as reasons to not kill himself and as reasons for living.
Did he express any current intent or plan?
No, he denied current intent or plan.
What about thoughts of harming others?
No, he denied thoughts of harming others.
How was his eye contact?
His eye contact was adequate.
What about his concentration?
His concentration was good as well.
How was his memory?
His memory, I would say, with respect to the alleged offense, particularly the alleged homicide offense, his memory was quite vague. He could not recall the events specifically surrounding that particular alleged offense. However, he was able to recall specific details leading up to the offense, as well as many specific details the day after the offense, the day of his arrest. And then he also demonstrated good recent memory with regards to his time since incarceration and his adjustment in the jail.
During the course of your evaluation, did you estimate his cognitive abilities?
I did. I estimated that his cognitive abilities fell probably within the below average to average range. And that was really based on Mr. Weathers' self-report of his academic and employment history, my review of school records, as well as Mr. Weathers' use of vocabulary and his conversational style and his ability to reason with me throughout the interview process.
And do those, I think you mentioned 5 different things there, do those 5 points allow you to come to that conclusion to a reasonable degree of certainty within your field?
Yes, I would say they gave me a pretty fair estimate at the time of the evaluation.
And with respect to his education records that you reviewed, what did those show?
Yes, so I reviewed records from 2 different school districts. They did show that Mr. Weathers had a history of special education services for speech and language impairment and for specific learning disability. They did include previous psychological testing results on 2 separate occasions. On both occasions, let me back up and say the first psychological testing results indicated overall low average intellectual functioning. The second psychological evaluation report, which I believe was completed 3 years later, did show that there was a large discrepancy between Mr. Weathers' verbal skills and his nonverbal skills, with his verbal skills being significantly lower. However, his overall cognitive abilities were shown to be within the low average range. And he was determined to have a specific learning disability, but this was noted multiple times throughout the records that this was not due to cognitive impairment or autism or anything like that. Cognitive impairment is typically what's a term used by the schools to denote what we would refer to as intellectual disability.
And what did some of those reports attribute his poor performance to?
Could you repeat that last part? I didn't quite hear you. I'm sorry.
You said they didn't attribute his performance on that testing to a cognitive impairment. What was the explanation for the reports that you reviewed for that?
Correct. Yeah. So they attributed it to more so being the result of a specific learning disability. And I also wanted to note too, I meant to mention this previously, he was also noted to display low average to average results on state and district school testing that's often conducted in the schools.
Do you know what grade level he completed?
He reported completing the 10th grade and stopping attending in the 11th grade.
Did any of the records you reviewed express an opinion about the likelihood for graduation for Mr. Weathers?
Yes, they did note that although he was receiving special education services and diagnosed with specific learning disability, that he would be expected to achieve a diploma.
And did you review his employment history with Mr. Weathers?
So what the information I had from Mr. Weathers was just based off his self-report of his employment history. Yes.
And what was that self-report?
He reported that at the time of his arrest, he had been working for approximately 1 month as he specifically used the terms barback and a bartender. He also reported that concurrently to that, he had been working for the last 4 to 5 years through a catering company.
And where was he working as a barback or bartender?
At Ford Field in Detroit.
And did he discuss his medical history with you?
He did. He did share that he had a history of seizures in childhood. I believe he noted that he said he experienced 2 seizures as a child, but that he has not experienced any seizures since that time, and it was not determined what caused these seizures. He also reported a history of a couple head injuries throughout his school years, which were obtained during like school gym classes. I believe he said he one time hit his head on the wall while playing volleyball. And he said he may have been diagnosed with a concussion, but he otherwise denied any lasting complications or ongoing sequelae related to those head injuries.
Were there any other significant medical issues that he noted?
Not that I can recall, no.
What about a history of substance abuse?
Mr. Weathers did note a history of substance abuse. He reported drinking alcohol pretty heavily around the time of the alleged offense, as well as in the years prior. He also reported a history of marijuana use and Percocet use.
Did he ever, per his self-report, do any substance abuse treatment?
He said he did not, no.
What about his mental health history? Did he provide a report regarding that?
He did. He noted that as a child, he saw a school counselor in school due to some emotional upset that he would often experience, some behavioral issues in school, bullying, things like that. He also noted that I think it was around the age of 10 or 11, from what he could recall, he was hospitalized. He was psychiatrically hospitalized due to similar issues, behaviors, mood dysregulation, upset, and was prescribed medication for a time. However, he said that once discharged and over the years, he stopped taking that medication and that he had not received any mental health treatment since that time until he was incarcerated on the current charges.
Did he note any history of depression or suicidal ideation?
He did. He noted a history of depressed mood, suicidal thoughts, one prior suicide attempt, I believe at the age of 18 or 19 via overdose and hanging. And then he noted the suicide attempt while in the county jail.
What about symptoms of manic episodes?
He did not endorse or report any symptoms of manic or hypomanic mood.
How about auditory hallucinations?
He did note that he started hearing voices. I believe he said they began at the age of 16. And he said these voices would come and go occasionally. That sometimes they would just kind of come on randomly. He did indicate a history of command hallucinations or voices that would command him to like harm others, for example, to like hit someone per se. So yes, he did note that.
What about delusions or bizarre thoughts?
No, he did not report any history of that.
How about paranoia?
No, he did not report any history of paranoia.
Any issues with hypervigilance?
He did note that being in jail, he had a certain level of hypervigilance or, kind of feeling like he needed to be on the lookout just due to the environment. But he said otherwise, he did not typically feel this way when not in jail.
What about mental health treatment that he has received while incarcerated? You said he reviewed those records. What did those show?
Yes, so that did show that Mr. Weathers was evaluated by mental health staff at the jail. It appeared that he was prescribed Seroquel and Rimron. Seroquel is an antipsychotic and Rimron is an antidepressant. These medications are often used to treat depression and sleep. He also was diagnosed with which was bipolar disorder and I believe an unspecified anxiety disorder along with a major depressive disorder. But it appeared in the evaluations at the jail that these diagnoses were given on the basis of Mr. Weathers' self-report of such history of diagnoses, as well as some of the depression and emotional upset that he displayed, particularly after a court hearing, I believe, while in the jail, and displaying some depression and some passive suicidal thoughts.
We talked a little bit earlier about the inventory of legal knowledge. What were the results of that test?
So he obtained a 39 out of 61. which is not indicative of feigned legal competence. Typically, or the cutoff score for this particular measure is 24. So any scores under 24 are considered to be strongly indicative of feigned legal competence. So while Mr. Weathers' score fell above that range, it still was within a range that was lower than would be expected to be obtained by individuals, even individuals with genuine mental illness. And so it gave the indication that possibly he was not putting forth his best effort on the measure.
And you specifically discussed his understanding of the nature and object of legal proceedings. Isn't that fair?
Yes, correct.
And what were the results of those discussions?
So throughout our evaluation, Mr. Weathers was able to state an understanding, a basic understanding of the nature and object of the proceedings against him. He was able to state and acknowledge the charges against him. He was able to acknowledge the seriousness of the offenses that he was facing, specifically stating they're trying to give me life. He was able to identify the roles of various court personnel, including the role of his defense attorney as being someone who's trying to help him out, the role of the prosecutor as someone who's against him, the role of jury, and they decide whether someone's guilty or not guilty. He was also able to identify various plea options in his case. He identified that a guilty plea would mean that the defendant is saying he did the crime. Not guilty plea would indicate that someone is saying they did not do the crime. He also demonstrated the understanding of a plea bargain, identifying that is when they lower the charge or the person cops a plea. So he was able to identify and voice an understanding of the nature and objects of the court proceedings.
What about specifically whether it would be wise to speak with me without Mr. Cripps present? Did you ask him about that?
Yes, I did. So we did discuss, he was aware of the adversarial nature of the legal system. He verbalized that it would not be wise to talk to the prosecuting attorney without his defense attorney there. And he did confirm that in doing so, if he were to do so, the prosecutor could try to get him in trouble, so to say.
So based on all of that information and the other information that you've reviewed and discussed today, were you able to form an opinion to a reasonable degree of certainty within your field regarding his ability to understand the nature and object of these proceedings?
Yes, I was.
And what was that opinion?
My opinion was that he was competent at the time of my evaluation.
And there's another prong that I wanted to discuss separately, assisting the defense in a rational manner. Isn't that something else you looked at?
Yes, I did.
And what did you find when you were looking at that piece?
Yes, so throughout my discussion with Mr. Weathers, I found, in my opinion, he was able to rationally assist in his case. This was demonstrated by his ability to discuss his case with me. While his memory at times was patchy and vague with regards to the alleged homicide, he was able to note many specific details of events leading up to the crime, the day after the crime. He was able to rationally and logically discuss his case. His answers were very relevant to his case. He was able to identify different concepts, such as potential evidence that the prosecution could bring against him, and then as well as rational arguments in his defense. And he was able to take information from the police report that I reviewed and provided to him and apply that to his case and discuss rational arguments in his defense.
Did you discuss with them what might happen if him and Mr. Cripps have a disagreement regarding how to proceed with the case?
I did. I believe he responded that he would have to talk with him about it if he were to disagree, and that they'd have to work something out.
Did you discuss what appropriate courtroom behavior might look like?
I did. He identified that one is to be on their best behavior in court. He was aware that if someone did not display appropriate courtroom behavior, they could, quote, catch another charge or get another charge. And so he demonstrated understanding regarding that.
And your evaluation of his ability to assist in his own defense in a rational manner, that weighed in the opinion of competence that you just provided a minute ago?
Yes, correct. That along with his understanding of the nature and object of the court proceedings.
Now, I provided you with the report of Dr. Abramsky in advance of this proceeding. Isn't that
Yes,
true?
you did. Yes, that's correct.
And you heard Dr. Abramsky testify here today?
Yes, I did.
And do you have an understanding of where her opinion differs from yours?
Yes, I do. It appears that she differs in opinion in that she believes Mr. Weathers is unable to rationally participate in his defense due to intellectual disability.
And do you agree with that conclusion?
I would say that at the time of my evaluation, I did not observe any signs or symptoms that would indicate Mr. Weathers was experiencing or Mr. Weathers had intellectual disability or significantly low cognitive functioning.
Is there anything else that you've reviewed that leads you to disagree with the conclusion that she's drawn in this case?
I would say my review of the school records leads me to disagree with that. As I mentioned before, previous school psychological testing results showed overall low average intellectual functioning. Additionally, IQ or intellectual functioning is considered to be stable over the course of typically stable over the course of one's lifetime. So I definitely would put more weight in those IQ scores at the time that Mr. Weathers was in school. He was not facing any significant legal charges at that time. Whereas any IQ testing performed today could potentially be impacted due to that situation. So that was another factor that weighed into my opinion.
Did you evaluate the testing that she included in her report?
Yes, I did. I reviewed those results.
And is there something you would have done differently with respect to that testing?
Yeah, so I mean, I noted that Dr. Abramsky indicated that Mr. Weathers' performance on those measures were poor, not his performance, I'm sorry, his effort appeared poor. Typically, when I administer an IQ test or a cognitive test of some sort, and typically what is also common practice is to also administer what's called a response style measure. There's a particular measure, what's called the validity indicator profile, which specifically measures a person's approach to the testing. It involves two subscales, a verbal and a nonverbal subscale, to be administered concurrently with an IQ test, such as the Wechsler Adult Intelligence Scale. And it really assesses, like I said, the individual's approach to the testing, whether they're putting forth effort, whether they're not putting forth their best effort. And it gives a better indication of how they might be performing on the other intellectual tests.
And when you say better indication, what do you mean by that?
So it would give an indication of the individual's approach to the testing. So for example, if their scores on the VIP indicated that they were not putting forth very good effort, then it would be safe to say that their effort on the concurrently administered intellectual test or cognitive test, you may need to take that into consideration and consider whether or not they may have been not putting forth their full effort on that test.
So considering what you heard in her testimony today and read in her report, does that change your ultimate opinion on Mr. Weathers' competency to stand trial?
No, it does not change my opinion.
I have no further questions, Your Honor.
Chris.
Thank you, Honor. Good afternoon, Doctor.
Good afternoon.
Thank you for your lengthy and comprehensive report in this matter. I just have a few brief questions because I know the judge is listening carefully.
Sure.
In relation to your contact with Mr. Weathers, did you meet with him once or more than once?
I met with him just the one time on November 18th.
And that was for a, if I understand it correctly, 2.5 hour interview?
Correct.
And did you conduct that interview by yourself?
I had a supervisor with me present throughout the entirety of the evaluation.
And you heard Dr. Abramsky mention that she had Ms. Kirsten Toth conduct some independent work regarding the neuropsychological assessment. Is that right?
Yes, I did.
Was any similar type thing done by the Forensic Center in relation to Mr. Weathers?
No, the only testing that was administered was the inventory of legal knowledge. The response style measure. Yeah.
All right. In terms of your contact with Mr. Weathers, I noticed your report indicates that he had an overall dysmic mood. That's DYSTHYMIC. I didn't know what that meant, so I had to look it up. But does that mean he had a long-term form of depression?
So yes, dysthymic mood, I believe is, yes, the term I used in the report. So that's more of a description of what would also be referred to as just kind of a mildly depressed mood.
Mildly depressed but long-term?
Not necessarily long-term. There is something that's referred to as dysthymic disorder. It's an older term that has been used to describe more chronic depression. However, it can also be used, the word dysthymic can also be used to just describe mood in the moment.
And you said it also was combined with a congruent effect. Could you explain what that means?
Yes, so it was combined with a congruent, or what would be called just a consistent affect. So Mr. Weathers, not only did he present with a mildly depressed or dysthymic mood, but he also reported feeling depressed. And this was also evidenced in his affect or his emotional expression, as indicated by a little bit of a limited emotional expression range. At times, there was a moment where he became tearful. So something that would be consistent with a mildly depressed mood.
And that led to your indications or report that he reported poor sleep in the jail?
Yes, in addition to his depression, he reported poor sleep in the jail.
And decreased appetite?
Correct.
And a suicide attempt, is that right?
Correct.
So you just, I believe you mentioned that there was more than one suicide attempt in his lifetime, is that right?
Yes, he reported attempting suicide, I believe at the age of 18 or 19 via hanging. And then he said when that was not successful, he attempted overdose.
And your report also indicated that he attempted, or he had, quote, recent suicidal ideation and a suicide attempt via hanging while in the jail itself, is that right?
Correct.
And that was just a few days prior to your evaluation?
Yes, yes, that's what he reported to me.
When you met with him, you do agree that he did report a poor memory of the alleged offense, is that correct?
Yes, that's correct.
And the incidents surrounding the offense were, in your words, vague at times.
Yes, particularly his memory as it pertained to the alleged homicide. He could not recall any details surrounding that particular alleged offense. However, he was able to state and recall various details leading up to that, as well as various details the day after and on the day of his arrest.
But you do also indicate in that section of the report that Mr. Weathers' cognitive abilities were in the below average to average range, is that right?
Yes, I estimated them to be within below average to average range. Again, that was based on his vocabulary, his use of vocabulary with me, his conversational style, his ability to reason during our conversations, as well as his self-reported academic history and my review of the school records.
And also you included it based on his ability or to reason throughout the interview, is that right?
Correct, yes.
That fit in with the below average to average range as to cognitive abilities.
Correct, yes, that was a factor as well.
You did examine records from the Wayne County Jail,
Yes,
is that right? And the records indicate that Mr. Weathers reported a history of bipolar disorder
yes,
along with depression,
that's correct.
and was given a diagnosis of bipolar disorder, unspecified major depressive disorder, and anxiety disorder, along with alcohol and cannabis dependence.
Yes, that's correct. That was in the Wayne County Jail records.
You also had the opportunity, along with those records, to review his Detroit Public School and Hamtramck's records, is that right?
Yes, that's correct.
And the results from psychological assessments, according to your report, indicated a low average intellectual function.
Yes,
Was
they
is it
indicated, I'm sorry, go ahead.
No, you go ahead.
Yeah, I was just gonna say they indicated overall low average intellectual functioning.
And particularly with a weakness in verbal conceptualization skills, is that right?
Yes, so the test results did note that Mr. Weathers did display more significant deficits in verbal skills as opposed to nonverbal skills. But again, that overall his overall general cognitive ability was within the low average range.
And that could affect ability to communicate with others, such as his lawyer.
It could. So low verbal skills could impact one's ability to communicate, to comprehend information. However, during my evaluation with Mr. Weathers, I did not display any significant impairment with regards to his ability to understand what I was saying. I did not have any difficulty understanding him. His responses were very relevant and appropriate, and he appeared to follow the conversation relevantly.
Now, you referenced a 2005 report that indicated that his verbal comprehension and working memory abilities fell within the extremely low range. Is that right?
Yes, that's correct.
And were commensurate, I guess, or equal to his performance on achievement tests regarding reading comprehension, and mathematical skills.
Yes, that's correct.
He was in the extremely low range there, is that right?
Yes, correct.
In your conclusion regarding Mr. Weathers, you would concede that according to your report, that collateral records do support that Mr. Weathers has a history of learning disability.
Yes, I would agree with that. That's correct.
And he has a self-reported history of intermittent auditory hallucinations, as you mentioned earlier, is that right?
Yes, that's correct.
And let's strike that. I don't have any further questions, John.
Anything else, Mr. Hicks?
No, Your Honor.
Hey, Doctor, I have a few questions for you as well.
Sure.
A person who has a severe intellectual disability or significantly low cognitive ability, would, in your opinion, would they be able to deliberately feign or malinger or exaggerate?
So it's possible that someone with genuine intellectual impairment or cognitive impairment could exaggerate their deficits. Yeah, so yes, I would say it's possible.
Is it also possible that if I'm facing some very serious charges, that I might purposely try to distance myself from those charges and try to feign, malingering, or exaggerate?
Yes, I would say that that would be a possibility for someone to do that in that situation.
Your expert opinion, am I correct in that you don't feel that the defendant suffers from a severe intellectual disability?
Yes, that's correct. It's my opinion, at the time that I evaluated Mr. Weathers, he did not present with any significant intellectual or cognitive impairment, in my opinion, no.
I listened to your testimony as well as Dr. Abramsky, and it sounds like you guys interviewed two different people at times.
Yeah.
You said that he was polite, he was able to understand what you were saying, and you were able to understand what he was saying. Is that correct?
That's correct.
You reviewed school records, and you said because of the circumstances here, you would more readily rely on those school records that deal with his IQ as opposed to the testing that's done as an IQ now while facing these charges. Is that right?
Yes, I would definitely put more weight and stock in those IQ scores at the time of his school testing, as he was not facing any significant legal charges at that time.
How long ago did he attend school?
Well, the testing was completed in 2002 and 2005. I want to say, if I remember correctly, he was in about the fifth or sixth grade when he was tested last. And I do
That's
know
a very long time ago.
Yes.
So could you expect some decline over the years?
So IQ is relatively stable over the lifetime. Now, while there could be some impact to cognitive ability and functioning, such as the result of, significant head injury or traumatic brain injury, generally over time, IQ is fairly stable. In addition,
I would have the same IQ in the sixth grade as I would as a law school graduate.
So yes, so generally the IQ would remain stable. Yes.
Okay, interesting. You mentioned something about having a closed head injury could affect the IQ at some period of time. Is that right?
It's possible. It's possible there's instances where someone may experience traumatic brain injury and that could impact their cognitive ability. However, in this case, I was not aware that Mr. Weathers had any history of significant traumatic brain injury. He did note a history of some head injuries, but reported that he did not experience any lasting complications or issues related to those injuries.
I think he said he had a concussion while in gym class. He ran into a wall, right?
Yes, that's what he reported.
Any questions based on my question?
Not on behalf of the bench, Your Honor.
Just very briefly, Your Honor.
Go ahead.
Dr. Hudson, you mentioned that the IQ testing last took place in 2005. But earlier in your testimony, you mentioned curriculum-based assessments and state/district-wide testing. Do you have any indication of when that would have taken place?
Off the top of my head, I cannot recall the year that took place. So it's possible that that was concurrent with around the same time as psychological testing or throughout the rest of his schooling years. He did attend school through the 11th grade. I think he stopped going in the 11th grade. So it's likely that he received that testing as well throughout his school years.
And what did that testing indicate again?
So that testing indicated overall low average to average functioning.
I don't have any further questions. Thank you, Doctor.
Thank you so much, Doctor. Appreciate your time.
Thank you. Would you like me to sign off now?
Yes, congratulations. You just been deemed as an expert in Judge King's court. Congrats.
Thank you so much. I appreciate it.
All right, have a good day.
Have a good day. Thank you.
All right, anything else, Mr. Hicks?
Nothing from the people, Your Honor.
Anything else, Mr. Cripps?
No, Your Honor, no further proofs.
All right, Mr. Cripps?
Thank you, Judge. I understand the standards. You and I have discussed this before in prior cases. If someone is deemed to be competent until you're convinced otherwise. I thought it was a very fruitful discussion by both doctors today in terms of an examination of Mr. Weathers. It's very difficult to read into somebody's mind in terms of their ability to be competent or not. As Dr. Abramsky and Dr. Hudson told the court, first hurdle, it's like a 2-hurdle race here. First hurdle is capacity to understand the criminal process, including the role of the participants. I think that hurdle probably has been attained in this case by testimony by both doctors. I think the main issue here for the court's determination is Mr. Weathers' ability to function in the legal process regarding his ability to consult with me, his counsel, in preparation for his defense. And that's why I believe his past educational records, his past IQ records become paramount in this case. A very interesting question by the court regarding IQ in terms of if there was obviously some elaborate testing done in the school system, and does someone's ability to increase their comprehension and IQ occur over the years. And Dr. Hudson gave a very interesting answer saying it really doesn't. So I think that makes even the records from the past that were both discussed by Dr. Abramsky in even greater detail by Dr. Hudson are very important in this case, because his IQ score places him in an extremely low range of functioning. As Dr. Abramsky said in her report, Mr. Weathers appears to be functioning at a grade school age. And the impairments of that type manifests itself in many areas. It affects his practical domain of functioning with challenges.
Which IQ scores are you referring to? In school or the testing that was recently done?
Well, I'm referring to the in school. Because Dr. Hudson's report talks about that his psychological assessment in 2002 indicated a low average intellectual functioning with a weakness in verbal conceptualization skills. An additional psychological assessment from 2005 indicated verbal comprehension and working memory abilities within the extremely low range and were commensurate at that low range with his performance on achievement tests, reading comprehension, mathematical skills. All of those tests are in the extremely low range according to her report. So this man is supposed to be able, with those conceptual difficulties, be able to communicate with me regarding the very serious homicide charges that are filed against him in this case. So even though he may have some working ability as to what a judge or a prosecutor or a defense lawyer does, his ability to communicate with his lawyer based on his deficits and abilities to, I guess, to rationally understand legal defenses, legal documents, and communicate that with me in terms of this case, we believe does not survive that second hurdle. So for the reasons articulated so well by Dr. Abramsky, I would ask that you find Mr. Devious Weathers to be not competent to stand trial. Thank you.
Thank you. Mr. Hicks.
Thank you, Judge King. I want to start with what I agree with Mr. Cripps on. He did articulate the standard here, but just to remind the court, the statute's very clear. A defendant to a criminal charge shall be presumed competent to stand trial. He shall be determined incompetent to stand trial only if he's incapable because of mental condition of understanding the nature and object of the proceedings against him, or of assisting in his defense in a rational manner. Mr. Cripps described those two prongs as two hurdles, and I would certainly disagree with him on that characterization because they're not hurdles for the prosecution to overcome. Mr. Weathers has the burden in this proceeding to demonstrate that he is not competent per that standard. So they're not hurdles for us to overcome. They're hurdles for Mr. Weathers to demonstrate that he can't meet that standard. The court mentioned that Dr. Abramsky and Dr. Hudson seem to talk to two different individuals, but both doctors agree that he meets that first, that there's no evidence that he is not competent per the first prong of that inquiry, as Mr. Cripps acknowledged. So really what we're talking about here is whether or not he is capable of assisting Mr. Cripps in a rational manner. The statute says the court shall determine the capacity of a defendant to assist in his defense by his ability to perform the tasks reasonably necessary for him to perform in the preparation of his defense and during his trial. As I think you picked up on, Judge King, in your questioning to Dr. Abramsky, it seems like her concern here relates largely to his inability to understand the minutia of legal terms and keep up with the pace of a courtroom and all the filings and motions that are going to take place before, as Mr. Cripps mentioned, this very serious case goes to trial if we get to that point. That isn't what the standard requires. The standard simply requires him to be able to assist Mr. Cripps in performing those tasks. We're not evaluating whether or not Mr. Weathers is capable of representing himself here. We're not evaluating whether or not Mr. Weathers is capable of passing the bar exam. We're simply attempting to determine whether or not Mr. Weathers has presented enough evidence that he isn't even capable of clearing that low threshold of just assisting Mr. Cripps in performing those tasks necessary. And based on the evidence presented here, I don't think he's met that standard. Dr. Abramsky's conclusion is based largely on his performance on that testing that has been readily discussed. I'm not going to go back through each test she performed, but on the testing that she completed, or her assistant completed, that measures his effort and potential malingering on the testing, that testing suggested that Mr. Weathers was not putting forth full effort, which is consistent throughout the school testing and throughout testing once he is began appearing here in court, where he ultimately had much lower functioning than what was reported during the course of his schooling. I disagree with Mr. Cripps' characterization with that specifically because Dr. Hudson noted that his curriculum-based assessments and statewide testing indicated low average to average range performance. That's far different from what Dr. Abramsky's testing indicated once this case began. Further, the psychological assessment from 2002 indicated low average intellectual functioning with a weakness in verbal conceptualization skills, but it specifically noted that that was likely due to low effort, which is what I was just mentioning on his effort being inconsistent here. I'd also like to talk about one other test completed by Dr. Abramsky, and that was the psychological testing that she performed, which indicated that Mr. Weathers had symptomology that you wouldn't even expect to find in someone that had serious, severe mental illness, which again, she acknowledged indicates that he was over-reporting here. He was exaggerating the severity of his impairment. I think the court should find that the defense has not met its burden and that Dr. Hudson's report based on the school records, which both doctors acknowledge IQ is stable throughout lifetime, support that he has the intellectual capacity to aid and assist in his own defense.
All right. Anything else, Mr. Cripps?
No, Your Honor. Thank you.
Okay. All right. So I don't think that any of us have the understanding that the defendant has to function as an attorney or some kind of Rhodes Scholar, or even as a law student. However, it is very important that the defendant be able to assist his attorney in his defense. So, and I've always considered that when I've had these competency hearings and reviewed the evaluations and so forth, when someone talks about not being able to assist in their defense, I think of it in terms of a person not being able to communicate or to explain or to otherwise be helpful with their attorney, or somebody who just sits there and refuses not to talk whatsoever, for whatever reason the case may be. The reports that I reviewed as it relates to this defendant talk about him putting forth minimal effort, but when pressed, able to communicate effectively, communicate logically. Operating with an IQ that is average or below average, doesn't necessarily mean that you're not able to convey information to another person. I learned something new here today about the IQ. I thought that maybe I can increase my IQ number if I study real hard. Apparently not, according to these guys. My IQ is what it was when I was 6 years old. It is what it is. The reports from Trey Public School in Hamtramck, the testing that was done at that time, indicates that he was operating at low average. The testing that was done just recently, after these charges were brought, suggests that they're extremely low range. Both doctors, or at least the defendant's doctor, Mr. Bramstein, indicates that there was evidence of some, that maybe the defendant was lingering. I think her report set it out more forcefully than what she said here in the testimony today. She said Mr. Weather's performance would be indicative of exaggeration and memory impairment. Well, I will submit to you that that may very well be the case if we're facing first-degree murder charges. That I may have some selective memory loss, particularly when it comes to the crime itself. That's what's going on. I don't remember what happened. I blacked out. I was drinking, I was taking pills up until the time. I remember everything leading up to that in a logical manner. And I can tell you everything that happened after that in a logical manner. That doesn't sound like a severe intellectual disability for someone operating with significant cognitive impairment. I think what the doctor Ramsey noted in her report that defendant that his performance may be indicative of exaggeration of memory impairment. It's probably spot on for obvious reasons. It's depression, lack of appetite, and all those kinds of things are in the Wayne County Jail. I think there's a lot of inmates in the Wayne County Jail that share that same experience. Based on what I hear, the food isn't very good, and I'm not necessarily happy to be there. So that doesn't surprise me. The other issues that were talked about regarding depressive state, and all that good stuff. Really are interesting, but doesn't necessarily tell me the defendant is able to assist his counsel, his defense. I think we all understand and appreciate, the defendant understands the nature of the proceedings against him, is able to tell what the function of each of us are. He knows what Mr. Cripps' function is, he knows what Mr. Pitt's function is, and he knows what my function is to some degree. He understands the charges that have been brought against him. That's not an issue. Whether or not he's able to assist Mr. Cripps in his defense is what was the issue. And I'm not satisfied that we've heard anything to suggest that he's not able to. As such, this court is going to find that the defendant is competent to stand trial. That being said, how would you like to proceed, Mr. Cripps?
We need to, at this point, set a date for the preliminary examination.
Okay, very well.
Thank you for the time.
That was a lot of fun. I enjoyed it. Thank you. I was April 25th. 11 o'clock.
Judge, I would ask for more than a week on this one. I do expect at least one civilian witness. And I want to make sure that the officer in charge has time to track them down, since it has been some time since this case was initiated.
May 2nd. Any time of day.
I'm open that day if that works for defense.
We have pretty lengthy. And I can't do that day.
Morning or afternoon?
For the morning, I have lengthy hearings on motions on the Kevin White case, which was the client defendant case. And of course, I don't know how long it is.
Or if it goes at all, in my experience, it will be fine.
I'm also open May 4th if the court and Mr. Cripps are open that day.
I could do it in the afternoon of May 4th.
Unfortunately, we have a Tiger game in the afternoon.
Oh.
So you don't think you could do May 2nd and 3rd?
I don't know, Judge. I don't know how long.
What time are you guys starting?
Not even sure as to that. I know it's in the morning. I know that Judge Ramsey doesn't get started till 9:30.
Yeah, if it's a Judge Ramsey case, then it may take Mr. Cripps a minute to get over here. I'm fully open the following week on your 2 homicide days as well, Judge, on May 9th and 11th.
May 9th, Mr. Cripps. Any time of day.
I'm starting a homicide trial on the 9th. Whoever's doing Judge Cruz's stuff.
How many witnesses do you have on this, Mr. Cripps?
It's been a minute since I've looked at it, Judge. I think at least 3. I don't think it's going to be a ton, but I am expecting at least 3.
About May 4th at 12 o'clock.
Judge, I do have a jury trial starting on the 3rd. I hope to settle that case so I can keep everybody apprised.
Start a trial on May 9th.
And Charles got a prosecutor's filed a 40 to 50 witnesses. So I'll be there for a while.
Must be a really strong case. 40 to 50 witnesses.
You probably did that.
Already broke rank and did instead of homicide. Is that you guys said a homicide for May 1st, Mr. Hicks? Was that you earlier?
I don't believe so, Judge.
That's Mr. McBride. About May 1st at 11. 11.
Yeah, I'm thinking I may be able to do the 4th. I really think I'm going to be settling that case on the 3rd, so the afternoon.
May 4th at 12.
If things backfire on that, I'll let everybody know right away. At what time did you say?
12 o'clock.
All right.
That works for the people.
All right, May 4th at 12 o'clock.
Thank you.
Thank you, Judge. I apologize for the confusion. For some reason, I had in my calendar that this was via Zoom.
Oh, you did. I believe at the time, Mr. Cripps wanted to know if his expert testified via Zoom. And you asked if yours could as well. And if you could as well, I said, sure, no problem. So there you go.
Sounds good.
Worked out fine. I thought the Zoom worked out. You could hear everything.
Have a good day, everybody.
Thank you too. Mr. Weathers is in good hands.
That's right.
He's not an attorney.
All right. Everybody have a good evening.
Thank you. You too.
hey, you know, I'm all about it. I don't know. Anybody report out? Yeah, because they're saying they don't know if it was powered. I'll just talk. I'm finna go out.